for example, if I were to start any company, I would think about all these steps. Unless you have an exit strategy, it will be a disaster. Okay, so when you start any company, you need to have an exit strategy also. Okay, and you need to prepare in such a way that you have the best strategy to get the maximum value for your company, right? So whenever, like for example, you work on a lot of M&A transactions, mergers and acquisitions, right? So when we do an audit on the companies, right, we find a lot of mistakes. Okay, and the company value will go down drastically if you end up making these kind of mistakes. Okay, so if you have this, like you should have an exit strategy. Like you need to know at what point you're gonna exit, right? So I see like a lot of companies, they struggle. For example, some companies they struggle at 25 employees, right? Some companies they struggle at 100 employees. They cannot grow further, right? If you are in that position, you either need to make a drastic step, or maybe it's time for you to exit and then restart a new company. Because I see some companies that started like 20, 30 years, 10, 15 years ago, they are stuck at 25 employees. Some of them are stuck at 50 employees. Some of them are stuck at 100 employees, right? When you get to that point, you either need to make a strong decision whether to merge with another company or sell it or whatever, right? So that you get the maximum benefit out of it. Okay, so now I will go through the typical mistakes that we see at each step of this process. Okay, so let's go to the next slide. Okay, in the US, whenever there is a federal law, it applies to all the states. It's same, the regulations are same for all the states, right? So federal law, like immigration is a federal law, like patent intellectual property is federal law. But when it comes to anything else, it's all state specific. So what applies in one state may not apply in another state. Okay, some of the mistakes that I see, a lot of times what happens is individuals incorporate their business only in Delaware. How many of you have incorporated your business in Delaware? Okay, and you run your offices from somewhere else, right? They will have their primary office at some other location, but they'll be actually incorporated in Delaware. This is a big red flag. Okay, I would not recommend doing that. So you need to incorporate your company in the state where you're operating from. Okay, also please do not have an office in a state where you're not registered. The other day we were filing an H1B and then we saw that the company had an address in one state, right? And they were actually not incorporated in that state. So if you're running a business without proper incorporation, that means the business does not exist. If the business does not exist, the H1B cannot be approved. Okay, I know a lot of USCIS officers do not go back and check every time, but if you're caught, then all the petitions that are filed by the company would be considered as null and void because the entity does not exist in the first place. The second mistake that I see, right? How many of you go back and regularly check if your state, like if your company incorporation is active? You check, that's good thing. Check, that's good thing. How many of you do that? Good. A lot of times I have been seeing, like what, especially during the cap time, right? Because that's when we actually go back and check to make sure that the company is actually in active status, right? Because every year you need to reactivate the status of your company, right? If it becomes inactive and if there is if you enter into any agreement while the status is inactive, or if you file any H1B petition or any immigration related paperwork while your company status is inactive, then it becomes considered as null and void, and the petition could be denied. Okay, So this is one thing that I want you to please pay close attention to. Make sure to check your incorporation status on a regular basis. Second mistake that I see, somebody incorporates, initially starts their business maybe in Virginia, right? Later on, they want to move their office to Texas. Okay, and then they want to be able to use all the credit, the AEI number, everything from the Virginia entity to Texas entity. So whenever you're doing that one, when you're opening an entity in Texas, you have to open it as a foreign corporation. Unless you open it as a foreign corporation, which is registered in Virginia, you cannot be using that EIN number or the credit for the company. I see a lot of CPAs making this mistake where they just incorporate a new business, because when you are incorporating a new business without actually connecting the original one that's incorporated in Virginia, right? You cannot be using the EIN number or the credit that you have for the company. The other thing is, sometimes it may be worth for you to have a single member LLC. I don't know how many of you do single member LLCs. Good. So in those cases, you may be like, in certain situations, you may be able to take an advantage when it comes to the ability to pay. Because if it's a single member LLC, you can use your personal tax returns also, right? But that only applies to small companies. Like when you're starting, you could start it that way, but very few vendors would be willing to work with LLCs, because LLCs are a little more not formal kind of thing, right? So so LLC you could start in, you can use it in the initial phase, but later on just move to corporation. Oh, failure to obtain necessary licenses. So for example, I'll take the example of Virginia itself, right? So in Virginia, you cannot be operating any business without taking the license from the county, right? So, for example, in Fairfax, like a lot of companies, they miss doing that one, because they only think about the requirements in other, like for example, if they have previously done business in another state, maybe New Jersey, right? Which may not require the local licensing. But there are other states that require local licensing. And if you run a business without obtaining those licenses, then it will have a huge effect on the company. Okay, so this could also, like if any petition is filed in violation of the state laws, right, it could be denied for that reason too. So you have to be very careful in knowing, understanding about the local licensing requirements before you start operating the business. Okay. Lot of companies operate from home, right? It's perfectly okay to have a home-based office as long as none of your employees will be working from home, right? Except you, who is the CEO of the company. If nobody else is working from that home office, then it's perfectly fine. But certain counties and certain cities, or like maybe the HOA also, have restrictions on those. Okay, if there is a restriction on operating a home-based company, then you should not operate it from there. These days, we have been seeing a lot of RFEs whenever we file H1B petitions using a home-based business, right? So at that point of time, you need to show that you're not violating any state or local laws by running a home-based business. Okay, but please make sure you don't mention that the employee would actually be working from that home business. If that happens, they need to get special permission. Okay? Good. Let's go to the next one. This will be an interesting one. How many of you do job postings? Good. When you're posting jobs, do you say that you're willing to sponsor H1Bs? You mentioned H1B sponsorship is available. So what would you state? Would you state H-1B sponsorship is available? Doesn't matter. The rules have been the same for the past many years. You do mention H-1B sponsorship is available, right? Good. That's completely illegal. You'll be in big trouble for that. There are a lot of companies that had to pay fines for that reason, because they mentioned that H-1B sponsorship was available, because it's a pure violation of Equal Employment Opportunity Commission, EEOC regulations. Okay, next. How many of you state anything related to OPT, CPT, or anything like that? How many of you mention about OPTs, CPTs when you're doing ads? That's also illegal. I'll get to that one. How many of you mention ads stating that you need someone who is a GC holder or a citizen? You do that? Kforce had to pay $900,000 as fine few months ago because they were placing ads stating that the position requires GC or a citizenship. How many of you are aware of this? You're aware of this? That's good. So you could actually look up DOJ versus Kforce, wherein Department of Justice came back and said that, hey, even if the client requires, even if the client states that they need someone who is a green card holder or a citizen, you still cannot ask for that in your job posting. Anywhere, job boards, company, like any of your websites and all those things. There are actually a few individuals in the US who are actually trying to look for those job postings, and then they'll send you demand letters. There was actually one guy, I think, was from Florida. So he sued maybe 50, 60 companies, IT companies. Every time they post an ad saying that, hey, we need someone willing to sponsor H-1Bs, he would just send a demand letter to them, and then they would not reply to that. And he was gonna just go and file a case with the EEOC, right? And then these individuals, these companies, instead of fighting the case, they would just pay him $25,000, $30,000 in settlement matter. And they would not discuss this outside. Actually, DICE has flagged him too. I cannot remember his name. George or Thomas, one of these two, but I can send you that information. So he filed like cases, like even some of my clients have been victims of his actions. Okay, so please be very careful when posting the jobs. Now you may be asking, hey, how do we post the jobs correctly, right? So instead of stating that H-1B sponsorship is available, what can you state? Huh? Okay. Okay, we need someone who should be authorized to work, or visa sponsorship available. That's perfectly fine. You could say that visa sponsorship is available, but you cannot say that H-1B visa sponsorship is available. Okay, instead of stating that you need someone who is a green card holder or a citizen, right? You could just mention that you need someone with security clearance. Okay, and do not mention that H-1B visa sponsorship is not available. A lot of people do that also. On the ad, they mention that H-1B sponsorship is not available. Even that is illegal. Okay, let's just go to some of the sentences that are illegal. H-1B sponsorship available. That's actually incorrect. OPT certificates are welcome. That's also incorrect. So no H-1B, OPT, or CPT or H-4EAD. That's also illegal. Green card certificate needed. That's also illegal. Not okay. So how many of you are familiar with the wage transparency laws? How many of you are familiar with the wage transparency law? Good. How many of you have an office in the state of Washington? You have an office in Washington? Good. I'll tell you something about it. Okay. So how many of you actually have placed at least one of your employees in the state of Washington? Most of you. Okay. So look up Washington wage transparency laws. So there is a company called Inside Global. How many of you know about this company? Wow. Okay. Good. They actually had to pay $5,000 for every individual that had applied for a position with them, because they violated the wage transparency laws. You could actually look it up online. Just type in wage transparency and then type in Inside Global. You'll be able to see that one. They had to pay $5,000 as fine. For example, if they had like 20 job postings and 100 people have applied for it, right? For each of those, everybody who applied for a position with them were able to get $5,000 in settlement, plus the attorney fees. You know what the mistake that they did? Because most of the states now have the wage transparency laws, which require you to actually mention the salary range for the position. If you miss doing that one, then you're held liable. Okay. So especially in Washington State, I'm giving this example of Washington State because Inside Global pretty much everybody knows, right? So since they had to pay this fine, so that's why I want to give it to you as an example, right? And the worst thing about these regulations, right? So Washington State laws for wage transparency not only applies to those companies that have their office in Washington, but also any company that operates in the US, which has more than 15 employees, as long as at least one employee works from the state of Washington. So if you're a New Jersey based business having 30, 40 employees and at least one of your employees has worked for Microsoft, right? Then you'll be still be subject to the Washington's wage transparency laws. Actually, there is a newsletter on our website, so maybe one of you can get it. Anyone from the litigation team here? Shreyas? Or one of you please share the link for the newsletter that we have written. We have clearly cited the issue that happened with Inside Global also. And this not only affects the employers in the state of Washington, but also employers throughout the country. Unfortunately, there are a few attorneys who look for such job postings and then if they like, then just send you a demand letter. You don't want to be a victim of that one. Shreyas, there is a newsletter on Washington Wage Transparency website. Okay? Here's the link. So, and the correct way of posting jobs. You could mention visa sponsorship is available. Okay? Security clearance needed. Must be authorized to work in the US. Right? These are the things that you could mention instead of stating that OPT, CPT, or H1B, or H4EAD, or anything like that. Some of you may be asking, Santosh, what is the difference between stating H1B sponsorship available and then visa sponsorship is available, right? I'm surprised that nobody asked that question. Can someone think of a reason why stating visa sponsorship is available is legal, whereas stating that H1B visa sponsorship is available is illegal? Yes. Yes. Right? So if you specifically mention H1B sponsorship is available, that means you are discriminating against other visa holders. Right? So if you are stating that GC green card or citizenship is required, that means you're actually discriminating against people who have who are authorized to continue staying and working in the US based on asylum or any other applications, right? So if any of your job postings are in violation or are in discriminating in nature, then it's a problem. There are a lot of EEOC complaints that happen, and then people just pay money to settle it, and then there are a lot of companies that got in trouble also. I mean, I'm going to ask you another question. How many of you know that Apple had to pay, I think they paid 50 million or $5 million because they were violations with their perm job postings? Is it 50 million? How many of you are aware of this? Okay. I'll get to that in some time. Because there are a lot of things that you need to be aware of. It's not just about running the business. You need to be able to protect your business, and then you need to make sure nobody comes and sues you for any reason. Right? Okay. I'll get to that in some time. Are we clear on these, or does anyone have any questions? Let's do one thing. I'm going to take some questions for every step. Okay. So far, do you have any questions on step number 1 or step number 2? Anyone has any questions regarding the job postings? Okay. So now that you did hear about this one, what is the first step that you would do? For example, you're posting your job, like you're a company. Where are you based out of? Where is your company based out of? Atlanta, right? Okay. So what is the first step that you would do? Okay. Next.
To the different job platforms.
Okay. What is the important step that you need to do? Another important step that you need to take. Look up the wage transparency laws in your state. Right? That's a very important thing. I don't know, like if you're seeing, when you're doing the GC postings, right? Some of the newspaper ads may be asking, hey, you need to mention the salary. How many of you encountered this? You encountered this one? You know why they are doing that one? Because that particular state actually requires you to post, has strict wage transparency laws. And that newspaper agency also could be held liable for that reason. So that's why they don't post any of your jobs until you mention the salary. Not all states are doing that one. Like not all states have such stringent laws, but they have. But still, it's a violation if you don't post it, right? So and even New Jersey is moving towards requiring having wage transparency laws. Washington, California has one, and they're pretty strict about it too. So be very careful. The other issue with this is, since you'll be mentioning that the position requires travel or relocation to various unanticipated client locations throughout the US, right? So even though the company is in a particular state, maybe in New Jersey, right? Since you're making this job available for candidates from other places, because you're saying that the person could be working from other states also, right? These laws will also come into picture. So whenever you're doing these job postings, please make sure that whatever the post that you're making will pass the minimum mustard required, like in all these states. Is that clear? Okay, next. Good. Okay. I'm going to ask you one thing. So now you have posted the job, right? And somebody applied for a position, right? You posted the job on the job board. Somebody applied for the position. Now there's a client who is like the person applied for a Java position, right? And there is a client that is looking for a Java developer. Before you submit, the candidate's resume to the client, what are the steps that you need to take? What would you do? Huh? Go ahead. Yeah, you're right. You're right to represent. Next. A lot of companies make mistake here. Make sure you have a proper agreement with the beneficiary. Like when I say beneficiary, the employee or prospective contractor, right? Clearly stating that you have the right to submit his resume to the client. Okay, I'll tell you why this is very important. That's one thing. Next, you should have the exclusive right. Not just right, but exclusive right. And that he did not enter into any contracts that will conflict with this position. Right? And then also mention about the non-compete non-solicitation clause. Okay, because what happens is, I'll give a small example. Assume that somebody applied for a Java developer position with you. Okay, and of course, you need to clearly mention which client you are submitting his resume to. That's also very important. So assume that you took somebody's resume, you submitted it to a client. Now the employee, but the employee does not know that you submitted this to a particular client, right? Now the employee is working through some other vendor to submit his resume to the same client, right? Although you have it, because a lot of times they have these generic agreements where you'll have non-compete clauses and all that stuff, but you cannot use it against the employee until you make the employee clearly aware that this is the client that you're submitting it to, okay, and that you have the exclusive right. The worst thing is the employee can come back and sue you for the reason. For example, if he is losing his job because you submitted his resume without his knowledge, then he could actually sue you for damages. So it's very important that you have a proper agreement in place such that you have the exclusive right to represent, to submit his resume to the client, and then the non-compete clause and all that stuff. Okay, and also this is where you need to actually have the agreement, the clause stating that if the client accepts your resume and if you pass the interview and all that stuff, you have to join the client. Okay, not only that, you could also put in a clause stating that, hey, if you join this client, then you'll be getting so much bonus, and in exchange for receiving this bonus, you agree that you will continue working on this project for such a long duration. What happens is a lot of times we see that the employers try to keep the early cessation penalty in their employment agreement, right? So what they do is they have a clause stating that, hey, you cannot leave the company for like 2 years or whatever, right? So if you have such clause in the employment agreements, it could be a violation of the Fair Labor Standards Act. So look up FLSA, I think it's 62 or 71. Anyone from the litigation team? Okay, look up FLSA fact sheet 62, and that clearly states that an employer cannot have a leave cessation clause for non-immigrant H-1B workers. But again, there is an exception for it, right? The employer can have such clause as long as it is allowed by the state law, right? So instead of clearly having it only for the H-1B employees, since you are having that at the initial stage, which is at the time of submitting the resume to the client, right? It's not just for the H-1B worker, it's for everybody. That will be acceptable. Is that clear? Okay. Second thing is, make sure you do not have any illegal terms in your employment agreement. If you have one illegal term also, it will work against you. Even if it is not the if it's not leading to the cause of action, you still could be held liable for that. How many of you had any DOL investigation in the recent past, wherein an employee went and complained to the Department of Labor, stating that you did not pay the salary or whatever. Did anyone have any dual investigation in the recent past? Okay. The first thing that they're going to ask you in that one is regarding the public access files, of course. The second thing would be they'll ask you, hey, did you have any clause in your employment agreement that would restrict the employee from leaving the employment within certain period of time? That's the first question that they typically ask, because they're actually looking for that early cessation penalty. Right? So please make sure you do not have those clauses in the employment agreement itself. Is that clear? Oh, the other thing is, for example, now when you submitted the resume for the candidate, right? Make sure to have a liquidated damages clause. Okay, do not, because if you leave that one, then it will be on the burden of proof will be on you to prove that you have actually incurred damages. Okay, which is very subject to, and it will be a headache for you to defend yourself. Right? Instead, I recommend having a liquidated damages clause saying that, hey, we are like this guy, since it's tough to actually calculate the actual damages, so you'll be incurring like maybe $15,000, whatever, as liquidated damages. Is that clear? Oh, the other thing is, a lot of times what we see, immigration is a federal law, right? The same rules apply throughout the country. Whereas whenever you are looking at an employment agreement or any litigation matters, these are all state specific. The agreement that is valid in one state may not be valid in another state. Okay, so whenever you have an agreement that is drafted, right? So you need to look up the choice of law for that agreement and make sure it is reviewed by the attorney who is working in that particular state. Right? Even ourselves too, right? So although we practice immigration in all 50 states, we practice litigation matters only in 14 states. Only in those 14 states, we have the authority to review the agreements and guide you on those. Okay, if you want to look up the 14 states, maybe just go to the initial slide where they can see the state. Make it quick, if not, we'll just move on. Are you able to see that slide? Or you can just go to my profile. Okay, so I myself can review the agreements only in these: Arizona, District of Columbia, Georgia, Illinois, Maryland, Michigan, New Jersey, New York, North Carolina, Ohio, Pennsylvania, Texas, Virginia, and Washington. So I can represent any clients in litigation matters if they are from these states or if the choice of law is from these states. So if your company is not in one of these states, then it's tough for us to represent. Okay, so let's go back. Okay. Next thing. Go back. Make sure when you are entering into an employment agreement with the candidates, right? You clearly mention that the employee cannot directly contact the client, because most of the times what happens is the vendors have clauses in their agreement that says that, hey, if an employee or a contractor of yours contacts the client, then you'll end up paying liquidated damages, right? or if the employee tries to seek any other benefit, right? Maybe it's a different job or whatever, then you have to pay so much in penalty, right? So you got to make sure that you have certain clauses in the employment agreement that will restrict the employee from doing that. Okay. Also, you need to have an indemnification clause. What's an indemnification clause? For example, if somebody does something, like for example, I enter into a contract with you to place one of your employees at a client, right? And the employee does something, right? The client is going to sue me, not you, because I have the contract with the client, right? So if I have an indemnification clause with you, then whatever damages that I incur, I can put on. So that's an indemnification clause. Okay. Also, when it comes to the non-compete, non-solicitation clauses, the clauses that are applicable in one state would not be applicable in another state. I'll give a small example. I'll give an example between the same clause, how it applies in Virginia and New Jersey. Okay. Assume that in the non-compete clause says that, hey, you cannot work for this client for 1 year, right, after you leave our project, right? The same clause, if you have in Virginia agreement and New Jersey agreement, New Jersey judge may allow that one, but Virginia judge will not allow it. Okay, there are a lot more factors that they look at in these situations. There is something called blue pencil doctrine also, wherein the judge can make some certain modifications to the regulation, to the agreement, and to implement it. So, but it's a total different topic. So I don't not going to go in more depth with it. But I want you to thoroughly, whenever you have these clauses, make sure it's as per the state law that you are using as a choice of law. Okay. Also, be very careful whenever you have an employee working from the state of California. How many of you have employees working from the state of California? Good. Be very careful with it. Do not, even like for example, even if he breaks a non-compete clause, do not sue them. Okay, I'll be one of the worst statutes that they have is that, for example, if you have an employee who has breached a non-compete clauses, but he is based out of California, he's living in California, right? Even if you are able to obtain an injunction order in your particular state, they can actually file a case against you in California, and they can seek all sort of damage. So, rule of thumb is, if you have an employee working from the state of California, do not sue them based on non-compete clause. Right? Of course, there are other ways to get around that one, but usually if it's an employment agreement, if you have a non-compete clause and the employee is based out of California, try to avoid it. Oh, go back. How many of you are familiar with choice of law and venue? Okay, so choice of law is the state speaks about which state law applies, right? And the venue speaks about where you can file the lawsuit. So for example, if you are a company based out of New Jersey, then you want to keep the choice of law in New Jersey as well as the venue also in New Jersey, because if you have to file a lawsuit in some other state, for example, if the other party is in Michigan, right? Instead of you going and filing a lawsuit in Michigan, you would want them to file a case against you in your home state. So you got to be very careful when reviewing the choice of law as well as venue. Also, make sure you need to decide whether you want to go for litigation in court or an arbitration. Okay, please do not have arbitration clauses in your employment agreement. Whereas if you have an even for example, if you are giving subcontract, like if you are signing an MSA with a client, right? Make sure even they don't have an arbitration clause. Okay, you could, because if they stop paying you, right? For example, what happens is usually people have arbitration clause and they'll stop paying you for the last 1 month or 2 months. If they have the arbitration clause, then you cannot file a lawsuit in the court. you have to go through the arbitration process, which is going to be very expensive, okay, and a cumbersome process. Whereas if I were to give a subcontracting agreement to somebody, I would try to put that arbitration clause because I don't want them to sue me easily. Is that clear? Okay. Liquidation clauses. Okay, this is also very important. So, for example, you have placed one of your employee to work through a vendor, right? And the vendor has stopped paying you, like, or maybe they are delaying payments, right? But the vendor has the contract agreement between you and the vendor states that hey, you have to continue providing the services until the end of the project, right? If not, you have to pay damages, right? So now you're kind of stuck, right? Because you cannot stop providing the services, because if you stop providing the services, then you are violating the agreement itself, right? But here you're not receiving money from the vendor also, right? In those cases, if you have an anticipated repudiation clause, right, stating that hey, if there is any delays in payment, receiving payments from the vendor, you can actually send them a letter saying that hey, you have to queue this, right? If you do not queue this, then it's a violation of the contract, and that breach of contract, and that we can actually cancel the contract. So make sure to have those clauses in your agreement. Oh, how many of you know about ambiguous terms? So whenever, I'll give a small example. Whenever an employee reaches out to us saying that, hey, it looks like I have a new, like I want to join the client directly or whatever, right? When we look at the contract, if we see that there's an ambiguous term, when I say ambiguous term, whether if the terms of the contract are conflicting, right? So most of the time what happens is the offer letters and employment agreements, they copy it from somewhere, right? So if you're doing that one, then there will be clauses which could be contradicting with each other. Whenever you have an ambiguous term, when there's ambiguous term which is not clear or conflicting terms, right? It will be looked up against the master of the contract. So who is the master of the contract? The person who drafts the contract, right? So for an employment agreement, who is the master of the contract? Employer, right? If it's a vendor agreement, who is the master of the contract? The vendor, right? So whenever you have a term that is either ambiguous or inconsistent, right, or conflicting, then the term will be looked against the master of the contract. So be very careful with your employment agreements. If there is any clause in the employment agreement that is ambiguous, then you'll be the losing part. Is that clear? Okay. So I mentioned about the elicitation penalty, right? Look up FLSA fact sheet 62. Okay. So that one clearly says that you cannot have an early cessation penalty for a H-1B worker. But again, there is an exception for that, right? If it is allowed by the state law, then you can have the liquidated damages, right? So you need to make sure that when you have this clause, it is as per that state law. Please make sure you don't have any inappropriate fee payment clauses. Okay. Especially what happens is a lot of times the individual will not be on the project, and then you'll say that, hey, if you leave the company within certain period of time, you have to pay so much in damages, right? That's a pure violation. Okay. Although you're not clearly mentioning that it's visa applicable fees, the Department of Labor is still going to go after you for that. Oh, the other thing is, what is the statute of limitations whenever there is a DOL violation like this, wherein an employer took money for filing H1Bs, or like if there is any such issue. What is the statute of limitation? You know the statute of limitations, right? Statute of limitations is the time period that the Department of Labor can go back to look at the violation. Can anyone guess? Hmm? Lot of employers get confused. It's just 1 year. Yeah. Even Department of Labor, they are smart. They will not tell you that it's only 1 year. They'll start investigating the matter, and then once we get involved, and then we can like nail them down. Right? They cannot go after everything. Their review period is also very limited. They just can't do whatever they want to do. But you need to bring that up to them. How many times do you have FDNS people like visiting your office and asking for all sort of documentation? They not only ask you for documentation related to that particular employee, but also documentation related to everybody else. How many times have you encountered this one? Okay. As of today, the compliance with FDNS is still voluntary, right? Again, that's going to change from Jan 17, but as of today, they still don't have that right. It's just voluntary. So whenever you have any, like, do not provide any incriminating information to the officer, right? If you see that something is going wrong, you just tell them, hey, or talk to my attorney. I don't want to provide you with any more information, and then you can have that from there. Okay, but if you end up providing incriminating information to them, then we are screwed with them, because now they have access to everything. Is it clear? How many of you have moonlighting clause in your employment agreements? You do? Okay. How many of you have it? The reason why you need to include a moonlighting clause in employment agreement, and with the indemnification clause, is that, for example, if the vendor comes to know that the employee was actually working for some other client too during the same time, the vendor can actually sue you, stating that you submitted fraudulent timesheets, right? Because you submitted stating that you worked 8 hours for this client, right? At the same time, the employee was working for somebody else, right? So the client can actually sue the vendor can sue you, right? So in order to protect yourself, you need to include the moonlighting clause and have an indemnification clause, saying that the employee cannot be working for some other company, and that they will have to indemnify you for any damages that they have. That will be responsible for that reason. Is that clear? Oh, let's start. How many of you ask for H1B documentation when somebody applies for a position? You do? How many of you do that? Free flag. So what do you ask? How do you ask that? So if somebody applies for a position, and if you see that the person's name is Santosh Reddy, right? You directly ask them for H1B copy, right? Or OPT, CPT. How many of you know that it's a pure violation? How many of you know that it's a pure violation? It's a discriminatory act. Okay, I'm going to ask another question. How many times have you seen your vendors asking for those specific documents instead of saying we need I-9 documents? Why do they ask for I-9 documents instead of asking for H1B or citizenship card or CC card, whatever? Why do they ask for I-9? They could ask for example, see the way you asked, right? You look at Santosh's name and you ask for his H1B. right? At the same, similarly, why is it that the vendor is not asking you to provide that particular document directly? Instead, they're asking you to provide the I-9 documentation. Why do they do that? Yes, you're right. Who said that? That's right. Asking for a specific documentation is considered as discriminatory in nature. Okay, it's not only racial profiling, but also discriminatory in nature. If somebody can clearly document that, hey, this HR person is asking for this specific documents just by looking at my name or whatever, right? And if the person doesn't get hired, they can file a lawsuit against you. Okay, so you should not be asking for any particular document. What you need to do is you need to tell them, hey, you need to complete the I-9 form and send it to us with documentation to prove that you're authorized to work in the US. Right? Is that clear? Because they're like, I'm sure like you may not have encountered this because most of the employees or the applicants will also not know about these regulations. But if somebody wants to give you a hard time, yes, they can do that. So please do not ask for a specific document. Instead, ask them to complete the I-9 form and submit to you along with the evidence like documentary evidences to prove that they can work with or they are authorized to work in US. Is that clear? Okay. How many of you actually maintain public access? Yep. Can one of you raise your hand? I'm going to ask a question. How many of you, okay, how do you arrange your public access file? For example, you filed Santosh H1B transfer, right? So you have, what kind of documents do you put in this HR file? Huh?
I will put LCA along with PAF.
You'll put LC along with PAF, okay.
Yeah.
Do you put the any other HR document related, like I-9 documents also with that?
Yeah, definitely. We will even put the I-9 verification document that has been done for the employee.
You put it in the public access file?
No, not with public access file, in the employee folder we are saying.
Okay, do you actually mix the public access file with the HR file?
No, we never. We only put LCA and PAF.
Good. First thing, public access file is not for a particular entity, right? It's for the particular LC, right? Never ever club the LC in the public access file with the HR file. Lot of HR individuals make this mistake, wherein they club the HR file with the public access file. The Department of Labor officer has no right to look at your HR file directly. Okay, they can only look at your public access. So never ever keep these two things together. Lot of times what happens is they arrange the public access file based on the employee name. Don't do that. Keep it as per the LC. And how long do you maintain these public access files? Why? Okay, so assume that I file an LCA today, right, for a H1B transfer. Huh? No. Good. You need to see, the thing is you have to limit your liability. Okay, do not keep a public access file with you unless it's needed. If it's not needed, trash it. Don't keep it with you. This is the biggest mistake that a lot of people do. What happens is if there's a DeWalt investigation, they provide all public access files, right? And if there is a mistake in a public access file, they of course, nobody's perfect, right? You'll be doing one mistake or one mistake or the other in public access files too. You want to limit your liability. The way you limit your liability is you maintain the public access file for the duration duration of the LCA plus 1 year, or until the day you withdraw the LCA plus 1 year, whichever is the earliest. So for example, assume that you have an employee who has been working for you, the employee left, right? Of course, you would be doing the proper termination, all that stuff. I'll get to that later on. Apart from the termination, if you want to limit your liability on the public access file that you use based on that LC, right? What you need to do is you withdraw the LC. You withdraw the LC on that day, your liability ends 1 year from the day you withdraw the LC. Right? After that, you can remove that file. So if there's a dual investigation, you can say that, hey, these are the valid LCAs that we have for the company. Right? So this LCA is valid until so and so date. So we're keeping public access file only until so and so date. Once you hit the date, remove the public access file. Don't keep it. Is that clear? Because the more number of files that you have, the more number of mistakes that you make.
I have a similar doubts here, sir.
Yeah.
Yeah. For one employee, we might be filing 2 or 3 LCs, right? Considering these amendments.
Good.
Right. So in that case, how do we maintain the public access file?
Nice. That's a good question. So if I were to be in your shoes, this is what I would do. For example, if I file an amendment for a candidate, right? As soon as the HMB, once that amendment goes through, then I withdraw the old LCA. Because when I withdraw the old LCA, my liability ends 1 year from that day I withdraw the LCA, and then I can remove that file.
Okay, you meant to say
Like
only
question-
the latest LCA would be the public access file, right? The one which you find.
Yeah.
Thank you, sir.
So it's nothing to do with the employee itself. Like it has to do only with the LCA. If you have a valid LCA, you have to keep public access file until the validity of the LCA plus 1 year.
Understood, sir. Thank you.
Okay. How many of you keep the recruitment report whenever you do the GC cases, right? How many of you keep the recruitment reports with you? Only one person? 2, 3, 4? You need to have the recruitment report. I know Department of Labor has not been auditing these reports for a long time, but they can always come back and audit it. You need to, whenever you do conduct recruitment, you have to have those the recruitment reports available with you for 5 years. This is what you need for 5 years, not the public access file. Okay, one of the reasons. Sorry, are you recording all this? Okay, that's fine. But don't make it public though. So, recruitment report, right? So, whenever you conduct recruitment, right, you need to maintain those records for 5 years from the day you submit the form application. Lot of people don't. Okay. Not only that, one of the biggest challenges with the public access file, right, is that a lot of times you do not have documentary evidence to prove that the LCA posting was done properly. Right? So you had to be very careful with that too. So you need to limit your liability to as much extent as possible. Okay. So since we got into the GC public access file, I'm going to tell you about the typical mistakes that I see when it comes to processing GC application. Assume that you have 3 employees working. You can go back and check your records. Okay, so assume that you have 3 employees working in your company: employee A, employee B, and employee C. Right? Employee A has a all 3 of them are currently working as programmers. Right? Employee A has a master's in computer science. Employee B has bachelor's in computer science. Employee C has some other degree. The first time around, when you submit employee A's file for prompt processing, they will say the programmer requires a master's in computer science. Is that what you encounter? 6 months down the lane, you submit employees B file, then they'll say that same position requires a bachelor's degree in computer science. 1 year down the lane, you submit another profile, then they'll say that same position requires something. Right? Here, the issue is not with getting firm certification, because the firm will get certified because the officer is looking at one firm at a time. Right? But if there is an audit, the way I mentioned, right, they can come back and audit your files for 5 years. And at that point of time, if they realize that you are requiring inconsistent position requirements tailoring to the candidate, they might do a big audit on the company. Is that clear? How many of you understood whatever I just mentioned? Good. You had any question? Oh, you understood. Yeah. Because this is the typical mistake that lot of employers make. What they try to do is they try to match their current H1B job title with the beneficiary's qualifications and try to come up with a position requirement, which is a big no-no. The first thing is H1B job title need not match with the GC job title. How many of you know this? How many of you try to match H1B job title with the GC job title? Because the H1B job title could change from time to time, and GC is for a future employment, right? So, for example, if you place a candidate on H1B for one client, they may say that the position is Java developer, right? If you move them to a different client, they may say that Java consultant, or maybe consultant, or a software developer, right? The job title could be changing from client to client. Similarly, you will most probably be changing your H1B job title also. Right? The second mistake that I see with a lot of GC process. So assume that you send the explain letter for one of the candidates and it has a bunch of skill sets. C, C++, Java, HTML, .NET, MySQL, and all, SharePoint, everything. They try to put all these skill sets as the position requirements. How many of you do that? Wherein how many of you see ads which has bunch of skill sets in it? Pretty much a lot of people do that, right? That's actually incorrect way of doing it. Instead of mentioning all those skill sets, what you could have done is you could have just mentioned SharePoint and Java. The reason for this is anyone who knows SharePoint already know .NET, right? There is no reason to include .NET separately. You did not get any advantage by including .NET, right? But by unnecessarily including, similarly, anyone who knows Java already knows C, C++, HTML, MySQL, all those things. By unnecessarily including those skill sets as a requirement, it looks like as if you're tailoring the position to the candidate. Okay. All of these things will typically come into picture if there's an audit. Because, and then the other mistake I see, right? Sometimes it looks funny. So the position will be an SAP position and the position requirement will be in Java. Just because the employee had experience in Java, they try to put that as the skills required for the position. They don't look at the correlation between the actual position itself and the skills required. Right? And what happens is if there is an audit, then the employer has to provide an affidavit confirming that this is the minimum skills required, which is incorrect. And if any technical guy, if they look at it, they'll immediately get mistake. So you got to be very careful with that. So we'll do the first 5, and then take a 10-minute break, and then we'll get back. Oh. Especially with OPTs, right? OPTs and all, there is a lot of disconnect within the HR team members because of which they don't complete the I-9 form or E-Verify on time. They'll enter the information onto the service portal, but they will not be like conducting E-Verify or I-9. So this is very dangerous. So you need to synchronize the process within your company such that I-9, you try to complete it on day 1. Right? Although you have 3 days, try to complete them on day 1 itself, day 1 or day 2, one business. Right? Same thing for E-Verify. Because these days we have seen an increased number of I-9 audits. How many of you have encountered I-9 audits in the recent past? Okay. Because a lot of people approached us because they had an I-9 audit. Okay, so you got to be very careful with the timeline. You take a 5 minute break, then if you have 10 minutes, yeah, we'll take a 5 minute break or 10 minute break. Yeah. So first of all, let me tell you the reason for having a public access file. Okay, the reason for having public access file is that they want to make sure that a typical US worker knows what is happening in their office with respect to hiring a US, like a foreign worker, because that will ultimately affect their wages and everything, right? So the main aim of Department of Labor is to protect the local workforce. So anything to do with, whenever we deal with anything to do with Department of Labor, the main aim is to protect the US workforce, right? For that, they want to make sure, of course, since that is, of course, although that is the main aim, with that comes in, they want to make sure like the foreign workers are not treated badly, or they have very good, they have decent work environment, everything, because that will ultimately affect their the US work, right? So they want to see enough documentation regarding the position and what the like what kind of benefits the employees actually the foreign worker is getting. So first of all, we'll put the LCA, right? And then they need some documentation to prove that the LCA was actually posted on the exam. That means the information which was accessible to any US worker working at that location. So, and the other thing is, you need to post the LCAs. The LCA posting has to happen at the work location, wherever the beneficiary is working from, not from the petitioner's office or anywhere else. It has to have, because that is where the labor market is getting affected, right? Which is the ultimate work location. So you include the wage memorandum document, right? Which clearly identifies the wage that you're paying the candidate, the benefits that you're paying, and everything that you're paying the candidate, and also the way you came up with the prevailing wage and the LC. That's pretty much. Oh, what goes on the notice board is a small part of what is in the public access file. Because on the notice board, all you need to put is whatever the salary that you're paying the LCA itself. And then you need to provide them with a guideline as to who they can contact in case they have a question or whatever. Right. That whole documentation is going to go in the public access file. Right. So we take a 5 minute break. Yeah, let's do it that way. And then after this, we'll have another 5 slides. And after which I'm going to go through the H1B modernization rules that are going to go into effect, from Jan 17th. And then in the meantime, if you have any Q&As, let's do one thing. We'll have Q&A session first for a few minutes, and then I'll start the next 6 to 10 slides. Okay. Also, I want to make it beneficial for everybody. So if you have any questions, please feel free to ask. There's nothing like a silly question. So if you have any question, you can ask me. Okay.
Sir, I have a small
Sure, go ahead.
regarding wage laws.
Uh-huh.
So let's say our office is located at New Jersey,
Mm-hmm.
and employees work from home from Florida or
Mhm.
Texas, some
Mhm.
other state.
Mhm.
So in this case, which wage law needs to be considered?
Good. So since the company is based out of New Jersey, you would apply New Jersey law. Okay. But if if whenever you have a situation wherein if you mention that the position the person can work from anywhere in the country, then make sure like you need to look up the state law in that particular state where the beneficiary is working from. So for example, your company is based out of New Jersey, right? And you have at least one employee working in the state of Washington, right? And if you have that more than 15 employees, then you are subject to Washington wage transparency laws. But when they say Washington wage transparency laws, it only applies if the position is available for somebody to work from Washington. So for example, if you post an ad saying that the person, the work location is in New Jersey, then you don't have to worry about it because the position is not available for somebody in Washington to apply. Right? But when you are doing GC processing, right? Here you are stating that the position is available, right, for anyone in the country, right? Especially you're stating that the position requires travel or relocation to various unanticipated client locations throughout the US. That means the position is available for somebody from the state of Washington also, right? So it's better if you just include the wages in that one.
Thank you.
Okay? But if it's only specific to New Jersey, then you don't have to.
Thank you.
Again, a small disclaimer, New Jersey actually has the wage transparency laws now. You take a 5 minute break? Yeah.
Hello everyone. Please be back soon. We'll have a short raffle game after coming back. Thank you. Hello. Everyone, please settle down. We'll be starting soon.
Hello, everyone. So, shall we continue the session? Because it appears that we have to take a lunch break at 1:15. So, let's go through a few slides before that. Before we continue any further, right? So, I'm gonna like because some of them asked me a few questions. I'm gonna go through those questions with you also, because maybe you have the same or similar kind of doubts. So, I want to go through that, especially regarding the LCA postings. Go ahead. Sure. you can repeat it as well.
Great. If you can send, because I recently joined as a director with one of the IT consulting company, and this information seems to be pretty informative. If you can
Definitely.
share, that would be really helpful.
Yeah.
Thank you.
Because I just want to make sure, because some of the information you may not understand just by looking at the slides, but of course we don't have any problem sharing. Yeah. So somebody was asking, good.
I have a big question actually. So this generally looks simple, but I just would like to know one of the biggest points. Generally you say that it's must to be verified within 3 years. Yeah, we have been having cases that generally the candidates do not respond within the time frame. So what happens at such point of time? Why do
You are taking a huge risk.
and such point? What can we do to
You got to implement
miss that
the
risk?
rules strictly in your office so that that does not happen. You should just tell them that you cannot onboard them until they provide this information, period. Most of the times the issue occurs because the HR person is not paying attention or is not being diligent in getting the work done.
What if, what if the candidates generally do not respond on time? Because
Well,
we see that
don't give them the, for example, don't give them the experience, like the offer letter until they submit the document.
okay,
Because they need to submit it in for their service record and all that stuff, right? That's where you encounter these problems.
how about the other? Non-visa people, like citizens or green card.
Just tell them that you have to do it on day one, period.
Of course we do, but if they don't, is
If
there
they
any
don't, then you
chance of
tell them that, hey, if you don't,
missing that risky point?
I know, but if they don't, just tell them that, hey, if we cannot, do not provide this information the next because in the next 3 days, then we'll have to terminate your employment. If you say that you're going to terminate your employment, then they'll provide.
Okay, thanks.
Okay, I know it's not big. Somebody was asking me some questions regarding LCA, right? I want to go through that one. So on the LCA, if you look at it, it says that the public access, like it says something about placing the file at the principal place of business or the work location, right? You see that mark? Okay. Usually, what do you check? You check principal place of business, right? That's the company location. When you check that one, you're stating that the public access file will be at that location. You're not stating that the LCA posting is done at that location. Is that clear? The information that you're checking is for the location of the public access file. It's not the location where you're doing the LCA posting. The LCA posting has to be done at the work location. Is that clear? The second thing, how many of you, okay, let me ask you a question. On the H1, like when you file the H1B or LCS, right, it will ask you whether the position is exempt. Right? Can anyone explain why they are asking that question? Remember, like when you fill out the I-129 form also, it says the position is exempt because the person has a master's degree or higher, or you're paying him more than 60K. How many of you have seen that? Everybody has seen that, right? You know why they are asking for that one? Why they are verifying why they are checking to see if the position is exempt or not? Can anyone explain? No, no, no. That's a different exemption. I will get to that one also. No. No. Huh? This is very important because see, sometimes if there's an audit, right, all of these things will come into picture. Does anyone know why you're mentioning about the exemption on the 129? You guys remember, right? On the 129 form also, it asks whether the position is exempt. Then you'll mention, hey, the position is exempt because the person has a master's or higher or more than 60K. I'm sorry, can you hear the mic?
ఒక పర్సన్ ఎట్ ఏ టైం 2 to 3 ప్రాజెక్ట్స్ చేస్తున్నప్పుడు ఓవర్ టైం
This has nothing to do with overtime.
ఫ్లెక్సిబిలిటీ
Okay, I'll tell you the mistake that a lot of people do. Some of the HR individuals, because I've seen these, right? When they're filing the LCAs, they attest to certain things that they are not supposed to actually attest to. So they'll say that there is a section which says that, hey, by filing this LCA, we are not displacing any US worker, and that you have posted the job and that was made available to US worker and all. Have you seen that section? Can you pull up an LCA? So whatever the information that you're providing in the LCA, when you sign it, right, you're basically attesting it under the penalty of perjury that the information is right. Sometimes people end up making mistakes by selecting wrong stuff that is not actually required in most of the cases, right? So here, what they are speaking about is the exemption from doing additional recruitment or attestations, right? These additional attestations are in reference to like I don't want to confuse you. So basically, whenever you have a H1B dependent employer or an intentional violator, right, you have to attest to these things. This position did not displace in US or recruitment process has been conducted for this position unless the position is exempt. Okay, so the position is exempt if the employee has a master's degree or higher, or you're paying them more than 60K. The problem is, I have seen people at yes to this one, even if the position is exempt. So when you say yes, you are stuck with this one, because if there's an audit, they will ask you for all those files. Because whatever you mention attest here should be true. Is that clear? Especially this happens, these kind of situations happen whenever you're filing concurrent H1Bs, because there you'll be filing it for part-time positions also, right? And the salary could be lower. And then not only that, sometimes even if the position is exempt, you will not classify it as exempt. Maybe it's by mistake. We actually had a big RFP on this one. Remember? Yeah. So you got to be very careful with this. Is it clear, or should I go through any more detail? Okay. I'll tell you about the different exemptions, right? The exemption that somebody was discussing about the overtime, right? That's an exemption from overtime pay under Fair Labor Standards Act. What that means is that if a person is working more than 40 hours, right, the employer is required to pay overtime unless the position is exempt under the Fair Labor Standards Act. For that one, there are two different tests that you have to do, which is the job duties test and the salary test. But if the position is exempt, you don't have to pay them overtime. So for example, if you have a H1B worker and you file his H1B for full-time position, he's working on 2 projects, which is 80 hours, you're not required to pay them overtime unless you mention it in your offer letter or employment agreement. Right. There you even have the flexibility of either paying them straight or higher wage. But if you don't classify them as exempt, then you are stuck with the Fair Labor Standards Act, where you are required to pay at least 1.5 times the wage. Okay, so that is different. Here what we're talking about is exemption from doing additional attestations. These additional attestations are in reference to the fact that you did conduct recruitment before hiring the H1B worker. So basically what you need to say is that, for example, if you're placing a candidate at Apple, right, then you're attesting to the fact that Apple did not, you're placing them as a software developer. Then you're attesting to the fact that Apple did not, is not going to displace another software developer based on this H1B. And that you have conducted recruitment so that the position was available to a US worker, which we typically don't do when it comes to H1B, right? How many of you do the recruitment before you filing H1Bs? Unlike GCs, nobody does it for H1Bs, right? So you basically, automatically assume that it's an exempt position. Okay, which is okay, but you need to make sure that it's properly reflected on the HCA also. Because here, if you say that you did this one and then you agree to it, and you don't maintain those files, then you'll be at the hook. Is that clear? Good. So let's go. I'll tell you something. Whenever we do an audit, right, or whenever there's a litigation matter, most of the time nobody wants to do mistakes, right? It ends up that people are either, I wouldn't say lazy, but maybe ignorant, right? Whatever they could achieve legally, they end up like, I don't know. Sometimes it's not even the easy step that they take. They take hard, like much tougher steps, but it will create another violation. So you got to be very careful with these. Okay, let me ask you a question. Whenever you receive H1B approval for a candidate, right, you do their I-9. How many of you check the beneficiary, the passport expiration for the beneficiary? Good. Good. Why do you check it?
Whenever any H1B
clear
petition
now?
is being approved,
I'm sorry?
whenever any H1B petition is being approved by USCIS,
Uh-huh.
they definitely consider the passport expiry date as well. Let's say if we file the H1B petition for 3 years and the passport is getting expired in next 2 years, then his I-94 only, he'll get the I-94 only valid until his passport expiry date.
There is a trick to this one. I'll get to that. Anyone else? Okay. Here actually USCIS will approve it for 3 years. The issue is not with USCIS. Whatever you are saying is at the CBP level. So for example, assume that today you applied for somebody's H1B, right? The H1B got approved for the next 3 years. Then you have to look at his passport also, because in case if he travels outside the US, right? And when he's entering back into the country, he will receive I-94 only until the date his passport is valid. So instead of 3 years, now his I-94 is expiring in 2 years. So he cannot continue working past the 2 year period. And a lot of times, if the HR is brilliant enough to make sure that either the passport is still valid until the expiration of that H1B, or if it's not valid, then you have to keep an eye on when the benefits is traveling outside the US. So if I were to be in your shoes, what I would do is I would also mark the date his passport expires, because you know that if he has to travel for any reason, right, he will get I-94 only until that date. So few days before that passport expiration date, you need to check if he has extended his passport, and you also need to check if he has traveled outside the country. This is a very important step that lot of HR individuals miss. So please, whenever you see the H1B approval, you look at the H1B approval. Also, you may mark somewhere on your HR file stating that you have to follow up with the individual at least 1 month before his passport expires to see if he has traveled outside the country. If he did not travel outside the country, then no issues. But if he has traveled outside the country, then his I-94 will be shortened by the passport expiration date. Okay, this is a simple trick that you have to play in order to make sure that employee is not out of status.
So I have a small doubt here. Recently, the same scenario, I have filed a H1B petition where we got an approval until 2028 for the employee, but passport is getting expired in 2027 itself. So definitely, before the passport get expired, the employer has to exit the US, right?
No.
I mean to say come out of US
No,
and then
no, they don't have to exit. They don't have to. They can extend their passport while in the US itself.
so only extending the passport validity would be sufficient.
Yeah.
But
That's it.
again, in the I-94 copy,
Because the I-94, like, so they receive the I-94 from USCIS, right? Okay. First of all, let me take one step back. Okay. There are different authorities, right? One is the CBP, the other one is USCIS. CBP is the entity that issues I-94. Only CBP can issue an I-94. Is that clear?
Correct.
USCIS has the authority to extend the I-94,
correct.
right? So, in this case, right, when the beneficiary entered into the country, he received an I-94,
Correct.
right? Now, the beneficiary's I-94 has been extended by USCIS.
Yes.
He can stay in the country until the validity of that I-94 if he doesn't, as long as he doesn't leave the country.
So
Even if his passport expires, right? Even if he gets a new passport, since he already has that I-94, right? He is fine. But once he leaves the country, right, he'll get a new I-94.
that is what we want, sir, right? Because recently we filed amendment for the employee. Okay. So his I-94 was valid only until 2026.
Okay,
When we filed the amendment, it was amendment along with extension.
okay,
The passport is also getting expired in 2026.
okay.
Now the H4 is valid until 2027, let's say.
H1,
H1B petition.
okay.
But his I-94 is getting expired in 2026.
So when you say that his H1B is valid until 2077, right? Is that the latest? Like, did you apply for this H1B after he entered into the country?
Yeah.
Then his I-94 will be valid until 2027. When you get the H1B approval, right? You have the I-94 at the bottom.
Yeah, but the passport is valid only until 2026, na sir?
No, no, no. You have to look at the okay. So you have to look at the last action one, right? So what happened last? Was it his entry or you extending the I-94 with USCIS? Which one happened?
So recently we filed his H1B cap petition and he entered US. 1 year he was with us. Then recently we filed his amendment.
That's true. Did he go out of the country?
No, he did not.
If he did not go out of the country, then you look at the I-94 that was approved by USCIS.
Yes.
That will be valid until 2027 because typically they approve it until the duration of the H1B,
Okay.
right? USCIS does not approve H1B for 3 years and then give I-94 until 2 years. They would not do that. If they are doing it, they do it for the same period.
Okay, sir. Thank you.
Good, thank you. Is that clear or? No? Okay. So looks like they want to take a lunch break. I know I didn't go to even a single slide. Do you want me to? You want to take a lunch break? Okay, we'll go for 15 minutes and then take a break. Okay, so this is one mistake. I need I-9s. Okay, so I think I went through this one also, right? The statutory period when you need to enter there. I went through the public access file, green card, inconsistent position requirements. Okay, ability to pay. This is another mistake that a lot of employers or HR individuals make. How many of you have processed green card applications before? How many of you have processed green card applications, GC applications? Good. If the GC wage for a particular position is 120K, right? When is the employer required to pay that wage? Huh? No. So if the GC wage for the position is 120K, when is the employer required to start paying that 120K salary? Huh?
When
Yes. Once the green card is approved, you're right. So if the GC wage is 120K, the employer is required to pay that 120K once the person's GC is approved, right? But there's a catch here. The employer is required to prove that they have the ability to pay that 120K from the day you file the perm application, right? Good. How do you prove that the employer has the ability to pay? Anyone? Huh? Good. Okay. So here the GC wage is 120, right? And if you're already paying them 120K, it's clearly evident, right? If you're already paying them 120K, it's clearly evident that you have the ability to pay 120K. But if the employer is paying them 100K, right? Then you have to show that the employer has the capability to pay it, but they're not paying it because they're not required, right? So to show that, you'll show that the employer had net profits, which is equivalent to that difference, right? So you'll show that the employer had at least 20K in net profits for the company. Okay. And I know we mentioned about net assets also, but I'll get to it why I would not do net assets. I'll get to that one. So you typically show that the employer had 20K in profits. Similarly, if you have an employee who is not employed, like if you have a future employee for whom you want to do GC, right? How much profit do you need to show? Entire 120K. Okay, so that is the reason why typically unless you have profits, I would not recommend doing GCs for future candidates, right? Or make sure that they join you at least before you file the perm application. Okay, so now although regulations call out stating that, hey, you can use your net profit or net assets. Why did, like, there is a reason why I would not recommend using net assets, especially for 90 consulting firms. Do you know why? Any CPS here? Any account? Okay. So what they typically do is they try to put the depreciable assets, for example, if they have a car, right? So before they take the depreciation, they try to put it as an asset. But that asset is not available to pay the salary for the candidate, right? It's just that asset value is showing up on the tax returns only because you need to take the depreciation, right? So rule of thumb is the best thing to do is to use your profits when you're doing the calculation. In certain cases, if that doesn't work, then we also look at the assets. Of course, we look at the bank statements and everything, but generally try to avoid doing that one, especially if it's 90%. Is that clear? Good. Oh, issues with employment start dates. How soon can I? Okay, I'm gonna ask you a few questions. Assume that somebody is working for a company on H1B, right? And they want to transfer to a company. How soon can they start working?
Receipt is approved.
They can start earlier also.
Once we receive the receipt notice. Once we
Date of
receive the
filing.
receipt notice.
Yes. Once the petition is filed with USCIS, they can start working without receiving the receipt notice also. But we typically recommend that they wait until they receive the receipt notice because sometimes they may pull the petition or maybe the petition is not filed properly. Right? But they can start working once the petition reaches USCIS. But this is something they need to use only in case of emergency. Assume that somebody is currently working on H4 EAD and then you file the person's H1. When can they start working? Okay, forget about H4 EAD. I'm just saying that somebody is on H4, right? Somebody is on H4, you file for their H petition, right? Along with the change of status. And you file like because maybe they are already cap exempt because they have held H1B before. When can they start working?
Visa approved.
That's good. The person cannot start working until the petition is approved. Okay? AC21 portability, which allows an employee to start working with the receipt notice, does not apply if there is a request for change of status. Is that clear? What kind of mistakes do we see? Any questions regarding this one, regarding the start dates? Okay. Assume that you have an employee for whom you filed H1B. They're currently in India and then they came to the US. How soon do you need to start paying them? That's a mistake that a lot of people do. So assume that it takes 4 months for him to get an SSN for some reason. You're not paying for 4 months? Because this is something that the Department of Labor is going to check if there's an audit.
As we have clearly mentioned in the LCA that we are paying him the wages, as soon as he joins our company, we have to start paying him from the first day itself.
From the day from the day he makes himself available to work for you, you have to start paying him, right? So when I say making himself available, even if he's going through the recruitment, right? So where maybe he's attending calls and all, you're technically required to pay him from that day. Okay. If you do not, if the person doesn't have an and the maximum period that they have is 30 days to start running the payroll, right? So within 30 days, the employer has 30 days to take, like for example, if they can say that, hey, can join after 20 days or whatever, right? That's 30 days in the maximum period, right? Within that period, you have to start the payroll. If the person doesn't have an SSN, then you can still issue them the check, but withhold the taxes. So you'll run the numbers, you'll issue them check, right? The company check, and then later on, you will retain the money. Then you pay the taxes and all that stuff once the person gets SSN. Okay. How do you, for example, if there is an employee and you terminate their employment, but maybe they are on bench, right? Assume that Santosh is your employee and he has been working for a client for like 6 months and then now he is out of project, right? What steps do you need to take in order to make sure that you are not held liable to pay his salary? How do you terminate an employee? Which can be worker? What's that? Give.
H&B petition needs to be withdrawn.
Okay, what else? There are three main things that you have to follow. Unless you follow all these three things, it's not considered as proper termination and you could still be held liable.
The termination letter to be issued.
Termination letter needs to be issued. Okay, what is the other one? Huh? Okay, what else?
We have to send a termination letter.
Okay, there is an important thing that you have to include in the termination letter. What is it?
Liabilities.
No.
It will.
No. Yes, that's very important. So, a lot of like you have to do these three things in order to effectively terminate the H1B employee. Number one, you have to clearly indicate that the beneficial employee has been terminated. Right? Next, you have to offer them a ticket to go back to their home country. You don't have to offer it for their dependents, but for the H1B worker itself. And then you have to withdraw their H1B. Unless you do all these three things, you're still held liable. Okay. What employers do is they will send a they'll send a termination email or letter, they'll issue a letter to the employee, and then but the employee will still be going through the recruitment process. Right? They don't terminate their H1B. Right? So if whenever something like this happens, the employer is still held liable. Right? A lot of employers, they think that, hey, just because I sent the termination letter, I'm good. And then a lot of like the funny thing is sometimes they say that they have already sent the revocation letter to USCIS, but unless USCIS confirms that they have received the revocation letter, it's not valid. So whenever there is a dual investigation, the officer will check with USCIS to see if they have actually revoked the H1B or if they have received the revocation notice, the request. Okay, if USCIS states that they have not received the revocation notice, then they will not consider it. Of course, we can argue based on, like for example, we have the FedEx tracking number and everything, we can argue saying that, hey, this was sent, and they can provide an affidavit and all that stuff. But it's still, it is okay, it depends upon the officer. Okay, so whenever you are sending an H1B revocation letter, please send it through a medium that has tracking. I'm going to ask you a question. Assume that you have, that Santosh has been working for you for so many months and everything, but he's out of project. Okay, so what are the options that the person has in case if they want to continue staying in the country and then maybe market their services and all that stuff? What are the options available? Don't do that mistake. That's the biggest mistake that a lot of employers make, is to run their payroll, right? Because you have to pay the taxes and everything. That's going to be more expensive. Okay, so but during that 60 days, what do you do? Do you terminate their H1B?
Change of status to
Yep.
F1 or
Well,
any other H4.
I would not recommend F1. I would recommend B2 in this case. Right?
H4?
No, B2. H4 if it's an available, option is available. Right? So here is what typically, this is the best thing to do. check, first of all, check if the beneficiary has a valid visa stamping in their passport. Okay? If they have a valid visa stamping in their passport, then straight away just terminate their employment. Okay? Withdraw their H1B, offer them a ticket and everything. The employee now has 60 days to file for a change of status. Or they can come back and work for you. Now you can find another H1B, he can start working. You yourself can find another H1B for that candidate. Right? If the person is not able to get H1, like another job within the 60-day period, then they will apply for a change of status to B1, B2. That way the individual has another 6 months. So if the person is not able to get a job in 8 months, then maybe it's better for them to just leave it. Right? So the reason why I asked you to check if the person has a valid visa, right? So for example, if the person gets a job when the B2 application is still pending, right? Then there could be an RFP stating that the person is authorized to stay in the country based on a pending application which needs to be adjudicated before they can approve the H1B timing. Right? So if the person actually has a valid H1 visa, then you just request for confirm notification. In that way, once they get the approval, they can go out of the country, come back in using their old visa. Okay? But please do not do anything that is illegal, like running payrolls and then doing all those things. It's not worth the risk. Also, you'll end up spending more money. Imagine the amount of taxes that they would be paying in 6-month period or 8 months period. Instead, they could go to B1, B2 and come back to H1B whenever they get a pass. Is that clear?
Sir.
Yeah.
My question is, you said you have to offer a ticket for them, right? So
Ah.
that 60 days grace period, when does employee accept that ticket? Or how does he accept it? He has the choice of 60 days, so.
Okay. The employee, so you have to, okay. First of all, you have to terminate, right? The termination happens only after you offer him the ticket. Right? But it's up to the employee to continue staying, to either take the ticket and leave the country or continue staying in the country for 60 days.
Another question is, in that 60 days grace period, the same employer want to hire him back.
They can do, that's what I told you, right? You can just find another H1B and get him back.
But there's no option of waiting for the 60 days and make a decision.
No.
Of withdrawing the H1.
You could do that, but you are held liable to pay for that 60-day salary in case if the employee files a case with the Department of Labor.
Okay.
This happens all the time.
Yeah, they wait for that 30 or 40 days.
Yes, they wait for 60-day period, and now the beneficiary finds another job, right? And then maybe he needs pay stub, whatever, then they'll come back and, but it's not worth it.
But they'll save on the H1B fee, right?
But that's very minimum when compared to the taxes that you pay.
Talking about 1 month salary, 30 days.
Not worth the risk.
Okay.
Benching H1B workers, I think we went through that one. Okay. Not making proper records regarding the employee and their dependents, like the passport expiration, and then also making sure that the dependents I-94s are extended in timely manner. The mistake that I see lot of HR doing. Last thing is, when is an H1B amendment required? Huh?
Sir, any materialistic change will require an H1B amendment.
Yep. Any materialistic change requires a H1B amendment, right? What is considered as a material change?
Change in location.
Okay.
Change
Change on
in type.
location when it say, yes, if it's outside the metropolitan area, then it's a material change.
If it is within MSA, not required. Out of MSA, it is required.
Okay, I'm going to ask you another question. So assume that there are two clients in that same MSA. One is Apple, one is Microsoft, right? So you are moving the candidate from Apple to Microsoft, right? Do you need to file an amendment within the same? Maybe it's 10-mile radius, 10-mile distance.
Yes, definitely, because the clients are different.
Required, not required.
How do you avoid it?
In LCA,
No,
Addendum.
no,
In file LC and
no.
Excuse me.
LCA posting. He's right. Who said that one? Yeah. So if you actually post the LCA, right, for the required period before the beneficiary starts working at the new location, you're not actually required to file an amendment. Lot of times what happens is they move the employee within the same metropolitan area, but they don't do the LCA posting. Right? If you don't do that one, then you have to file an amendment.
So like I have doubt here. Within MSM is like what is the radius that we actually look into? Like, it's like 20 minutes.
Well,
or 50
rule
minutes
of thumb, look at the same county.
Same county.
Same county or the nearby counties which has the same wage levels and everything.
So
Okay.
if it is in the same
20,
county,
25
what
miles
is
is 25 miles is good.
25 miles to do. Okay. So if you're doing the job postings, then is that the appropriate way, or should we definitely file for an amendment?
No, if you are, like, see, the regulations state that whenever you're moving it then within the same metropolitan, because now it's a different work location, right? So you need to appraise the US worker at that location about this job.
Okay.
So you have to do the LCA posting.
Yeah, we'll do that.
The only thing that is, see here, there's nothing that is changing except for the location, right? But if you move them out of the metropolitan area, the wages are changing, everything is changing. The job market is also going to change.
Yeah, the title or the duties, everything
Whenever
remains
there is a
same.
change in the, whenever there is a change in the job duties or title or a substantial change in the salary, then also do an amendment
Okay.
because that's a material change.
Okay. We does a
So-
job posting. We don't file an amendment. But what in that case if he travel out of the content, he need to go for a stamping?
Okay, if going for the stamping, I highly recommend filing an amendment. Period. The reason is, so whenever you file a petition, right? So a copy of that will be sent to the PIN service center, to the service center, so that the visa officer would have access to it, right? So if you do not file amendment in the last scenario, right? Then the officer would think that the client is Apple, whereas the beneficiary is currently working for Microsoft, right? And that could lead to unnecessary equipment doing these and delays in processing their visas.
So if he's traveling out of the country, it's better to recommend filing for an
Yep.
amendment.
I also look at their identity force. If you think that you have to file an extension anyways, then better to file an amendment to this extension.
just change in salary also would need an amendment.
Of course, because you would not. It depends upon how much change it is, right? If a substantial change, yes, you would not. There will not be a substantial change unless there is a substantial change in the job duties or job profile.
Any
Typically.
range, sir? Let's say I'm being paid $80 and now it got increased to $90. Then in this case also amendment is required.
Well, usually if it's 10%, then it could be considered as a regular raise, but still 10% is a little high for that salary range. It all depends upon like whether the job duties are also remaining same or not.
Recently we have been to the situation, say, actually for one of the employees, everything was same, just there was a hike in salary. Okay, we have issued the hike letter to the employee. When we reached out to the attorneys that we are working with, they told that amendment is not required. So
Yeah.
just wanted to confirm.
Is if it is not required if it's like a regular raise. For example, if you're moving from a software developer to a senior software developer, then amendment is required. But if it's same job duties, everything is remaining the same, but it's small increase in salary, doesn't require an amendment.
Thanks.
So, I have a question.
Yeah.
So as you said, to change the status from H1B to B1, will it be easier or difficult to obtain a visa in this new administration, the Trump's administration?
You don't need a visa. So you just apply it with USCIS, and I've not seen anyone getting a denial for that.
Okay. After
because you can clearly state that, hey, I need time to wrap up my stuff and all that stuff. And we never say, usually we never see denials unless the person has violated his status.
after the employee obtains B1 and if he gets a project, then if we want to change him to H1, then
You need
should
to file his H1B under premium process. Okay, because he can start working for you only after he gets his H1B approved with
transfer
I-94.
or
So it'll be you'll just file it as a new employment with change of status.
thank you, sir.
Yeah, okay. Okay. Sure. So let's take a break, lunch break, and then. Okay. Yeah, I think. Okay. Okay.
Please wait 4 minutes.
Thank you.
So, for a note, we'll have a Q&A session at the end. So please write down your questions. Like we'll have a session for 1.5 hours. You can note it down and just keep it to yourself. You can ask Santosa at the end. Everyone will get an opportunity, so please don't be disappointed if your questions are not noticeable down. Also, you can please simply scan the QR code for the feedback and also follow us on Instagram. Just take a few minutes for that. Let's catch up for the lunch for 1 hour and just we'll get back soon. Please carry your ID cards because it's a private lunch, so we'll be serving you the lunch. So please carry your ID cards with you. Thank you.
Hi team, welcome back.
Guys, please settle down. We'll be starting soon.
Hello everyone, welcome back. So, is it clear? Good. Somebody was just asking me about the wage levels. How do we decide the wage levels for a position? Right? Let me go through that before we go to the next topic. Okay? So, rule of thumb, right? Whenever a position requires just a bachelor's degree minimum, right? It's level 1 position. Okay? Whenever a position requires a master's degree, it's level 2. Whenever a position requires bachelor's plus 5 years of experience, it's level 3. Right? When you're processing the PC applications, you mention about the travel requirement. So whenever there's a travel requirement for a position, everything jumps by 1 level. So if a position requires master's degree plus has a travel requirement, then it will be classified as level. Anybody wants to say? Which level will it be? Level 3, because level 2 plus 1, right? This is for the GC applications. Okay, so a lot of people have been asking us, hey, why do we get higher wage when you're doing GC applications when compared to H1B wages, right? So when you're doing filing H1Bs, you're looking at the work location for the beneficiary, so which could be anywhere, right? Whereas when you're doing GC applications, you're running the you'll be doing the wages from your principal place of business, because you're stating that the position requires travel or relocation to various places throughout the country, right? So for example, if your company is based out of California and you have an employee working from NC, North Carolina, right? So when you're filing the H1B, the wage will depend upon the NC location. Whereas when you're filing the person's green card, right, now you're looking at the company headquarters, which is in California. As I mentioned, for example, if you the wage depends upon the job location, right? The SOC code. SOC code means like the job duties, right? The job duties is decide which SOC code to be used, and the position requirements, right? If the position requirements is high, then it will be higher wage level, right? If the position requirement is just bachelor's plus 2 years of experience, then it probably be like maybe level 2, and if there's a travel, then it jumps by 1 level. Now, a lot of people have been asking us regarding the wage levels for H1Bs. Whatever I just mentioned right until now is for the GCA, right? So now regarding H1Bs, usually whenever you whenever you want to file a case, right? Then you send us the job duties, and we send you the, hey, this is the level 1 wage, level 2 wage, level 3 wage, level 4 wage, right? So typically what happens is, the reason why we do not recommend level 1 wage, right, is because there it states that the position minimum requirement is bachelor's. Of course, it should pass a muster, but most of the times, depending on the SOC code, it says that 95% of the positions require a bachelor's degree. Some do not, right? especially if it's for a systems analyst position or computer programmer. They will have a lower percentage of positions that require a bachelor's degree if you're going with level 1, right? That's a reason. To play safe, we ask for level 2, but we have filed many cases under level 1 without issues, right? All you got to prove is that this position is not complex enough that it would fall under level 2, right? But at the same time, it's complex enough so that the position requires a minimum of a bachelor's degree in a particular field of study, right? If you want to play safe, go with level 2. But it's not always possible for you to pay level 2 wage, right? So when situation arises, in those cases, we have to be very careful with in drafting the job duties and also stating the position requirements. Does anyone have questions regarding this? Okay. So sometimes you may be receiving high wage levels if you go with the FLC data center website, right? So in those cases, we could also request for alternative wage survey. I'll give a small example. If you're filing a software developer position in SFA, right? The typical wage would come around like 160K or 170K, right? But if you do a alternative wage survey, especially if the person is in like software developer and testing, the automation engineer, right? So the actual wages will be much lower than that. If you do an alternative survey, we can use that one. The problem with using alternative survey is that you have to request it for every position, because now the position change, like the wage changes based on the position as well as the work location, right? So unless you have a bunch of people working from one location, I usually do not request for alternative wage surveys. Okay. Also, there is a risk involved here because there are a lot of alternative wage surveys that are not being accepted by USCIS, right? So typically, in order to avoid all these situations, we just go with whatever is in the FLC data center and also go with level 2 because it's safe. Okay, but that does not necessarily mean that you have to change your business strategy, right? So if you have a situation wherein you're not able to pay wage 2 level, then you have to bring it to our attention, and then we can help you with redrafting the job duties or like maybe working around situation. Does that answer your question, Pradeep? That's a good question. So all it depends upon is the SOC code that you choose. Okay. The good thing about any IT position, right? If you give me any IT position, I can redraft it in such a way that I can make it fall into any SOC code that you ask me to. Because typically any IT position involves design, develop, test code, gather requirements. These are the only 4 words, right? Design, develop, test code, and then gather requirements. With these 4 words, I can rephrase the whole job duties. Okay, I can make it fall into a software developer, or if you want me to even make it to a database administrator, we can do that. Okay, because I know a lot of SOC codes don't even make sense, right? And these ESCS officers, most of them are Department of Labor officers also. They don't know, or they don't have much knowledge about the skill sets. For example, if you have a software developer position and one requiring is maybe one requires like maybe it's a big data developer, right? And then there's another one which is a testing position. They think both of them are the same. It's an automation engineer position which requires Selenium, right? So you cannot expect a person to get paid the same wage if the person is working on Selenium versus a big data, right? But as per the Department of Labor, they think it's the same thing. So the burden of proof is on you to articulate your job duties in such a way that you can satisfy the requirements. Same thing for GC also. It's easy to redraft the job duties in such a way that we can make sure that the SOC code, like if you feel that, hey, the salary for SOC code is so high, you can always redraft it. This like especially for clients who are in California, you got to be very careful because the wages are so high. California, New York, of course, other places also, depending on where you're based out of. Does anyone have questions regarding the wage levels? Because I know we have only a little bit time, so I want to go to the next topics. Anyone has questions regarding wage levels? Okay, let's go to the next one. Okay, payroll. This is a very important topic. How many of you hire OPTs? Good. How many of you issue offer letters to these OPTs? Good. How many of you really run their payroll? Okay. So whenever you hire a candidate, right? Okay, you have to look at two things. One is their immigration. The other one is Department of Labor requirements, right? Based on immigration requirements, a person can be on unpaid internship while on their OPT, right? But what dictates whether a position qualifies for unpaid internships is dictated in the fact sheet 70, sorry, which one, 71? 62, okay. If you look at fact sheet 62, it explains how and when you can classify a position as unpaid internship. Okay, so if the primary beneficiary of that internship is the employer, then the employer cannot classify it as an unpaid internship. So whether you have candidates working, like for example on H4EAD or GC, citizen, or even OPTs, right? If they are going through the recruitment process with you, and if you're having them attend visa interviews and all, you have to compensate them. You cannot classify it as unpaid internship. Okay, the worst thing about this is if a person has a claim for under unpaid internship, right? It will be classified under the Fair Labor Standards Act, which is a federal law. They can actually file a case in the federal court and make it a class action, stating that, Your Honor, not only me, there are other candidates also in this company who went through the similar training program, right? And make it the class action. How many of you are familiar with class action? Yeah. So once the judge certifies it as a class action for the class, then you pretty much lost the case. So you got to be very careful when you are issuing offer letters for unpaid internship. Make sure it meets the guidelines as specified in the Fair Labor Standards Act, fact sheet 62. 71. Okay, sorry, 71. Make a note of that because that's very important. There's a primary beneficiary test. You have to make sure that your job duties fall within that category. Okay. Also, the amount of wage that you have to pay for these interns, right? It should be similar to the wages that you pay for a typical intern. As long as it is more than the state minimum wage, you should be fine. Right? Also, you can classify the interns into different levels. You can classify them as intern 1, intern 2, intern 3, wherein intern 1 is maybe somebody who is an unpaid internship. But these unpaid internships can be only for a short duration of time. And during this time, they should be receiving training that is typically offered in a classroom setting. So you cannot say that a person is working as unpaid internship for 6 months. Does it make sense? A lot of times what happens is employers issue offer letters to these employees. They don't pay them, and the employee can always file a claim against the employer. Okay, so as long as you're paying them at least the state minimum wage, you should be fine. So if they get a project, then you can pay them intern. You can promote them to intern 2 position. It could be a different scale. Does it make sense? Okay, and then I think I also touched upon the exempt position, right? So if an employee, unless employee is exempt, you have to pay them overtime when they work more than 40 hours. Right? That we clear on that one. Okay. Next. Okay. So the other thing, whenever you are filing any H1B petition, right, requesting for a change of status or sorry, extension of status, I highly recommend that you go back and look at the previous petition. For example, if it's a transfer, right, and you receive the pay stub from the employee, ask them to provide a copy of their last LCA to verify that the work location that's mentioned in the pay stubs matches with the work location that was previously mentioned in the LCA. Right? Because if this previous petition was filed for a work location in California and the pay stubs were run in New York, then you will receive an RFP for that. Same thing applies if you're filing for an extension or amendment. Okay, it's very important that you cross-verify the address that is stated in the pay stubs versus the address that was stated in his last LCA or H1B petition. Okay, when you're verifying this, verify the salary also. The other thing, a lot of times what happens is, assume that a person has been like he's on bench for 6 months, right? Then somehow the employers, they try to run the pay stub for like July, August, September, and then they try to use it to file for an extension amendment. That's a big red flag, okay? Because even though you already run the payroll for just July, August, September, right? It will have a cumulative number also. The USCS officer is going to look at that number, and they will realize that you have not been running the payroll for the past 6 months, and then they'll issue an RFP on that. Okay, so you have to be very cautious before submitting payroll documents to USCIS. If you have a situation like this, then better to request for transfer notification so the person can go for stamping. Does anyone have questions regarding this? Okay, so number one, make sure to cross-verify the wages with the pay stub that the employee is providing. Make sure to cross-verify the work location. Okay. Next thing, assume that you filed somebody's H1B for 120K, right? And the person is working overtime, right? When you say 120K, it's $60 per hour, right? If the person has worked maybe 60 hours, right? So now the wage is 110. Assume that the LCA wage for a position is 120K, which equals 10K per month or $50 per hour, right? If you want to pay the beneficiary 16K, what do you do? Huh? I'm sorry.
The leftover can be given as in bonus amount. or
Good
type of
question.
incentives.
Good answer, but like you'll have to pay more taxes, right? And beneficiary would not want to do that. Huh? No. No. How long can you carry it? Okay. Lot of employers, what they do is they just put the flat number as 15. Okay. If you put that as 15, it's a red flag. Because the USCIS officer is going to question why you're paying them much higher wage than what is mentioned in the LC. Okay. Instead, what you could do is you could use the same $60 per hour, which is the regular wage, right? You can mention that one, getting $60 per hour, 12,000. Then you can have an additional line item for that extra. You can mention it as overtime and then provide that amount. That is acceptable. It doesn't matter. So you see, LCA exemption is for different thing, as I mentioned, right? That is for the displacement of workers and all that stuff, right? So if the position is exempt from the Fair Labor Standards Act, like regarding the wage payment, then the employer has the discretionary power to either pay them overtime or not. Even if they pay overtime, they can choose whether to pay the flat amount or higher amount. So you should always separate that line item. Okay, so by separating the line item, you're not violating the LCA regulations. You're paying them as per the LCA, plus you're paying them extra, which is allowed. Does that make sense? Okay. Yeah. So you're paying overtime or bonus, because a lot of employers don't want you to pay it as bonus because they'll have to pay more taxes. So you can do it as an overtime. Does it make sense? Any questions on this one? Well, overtime will be based on the regular listing, right?
Sir, I have part-time H1B.
Hmm.
Okay, can I run regular pay or I mentioned in LCA it's going to be 20 hours per week. But
If
we
you
have so much
mention-
amount.
okay. That's a good question. Okay. H1B can be filed for a part-time position, a full-time position, or for a range of hours. We clear on that one, right? So you can file H1B for 20 hours per week or a full-time position, or by specifying the number of hours, 20 to 35. Okay. If you file the H1B for 20 hours per week, you have to pay them for 20 hours. You cannot be paying more than that, because that's like working without authorization. If you mention 20 to 35 hours, the person has to work anywhere between 20 to 35 hours and you have to pay them accordingly. But when you specify full time, right, the person can work for a number of hours, which is about 30 to 35. So if it's a full time position, he can work for 60, 70, 80 hours also. And lot of times, this is another issue that I see. Lot of times, if a beneficiary is if an employee is working on multiple projects, during site visits, the employee can clearly say that, hey, I'm working on multiple projects. That's perfectly fine. It's not a violation. It is not a violation to work for more than 40 hours. It's okay to work for 80 hours also, as long as it's a full-time position. Okay? And a lot of times what ends up happening is the employee is going to say something and the employee is going to say something. Now you're charged with perjury. Right? Don't do that mistake. You're perfectly fine to work more than 40 hours. Okay. Also, it's not mandatory that the employer has to pay overtime unless it's specified in the offer letter or employment agreement. Is that clear?
Do we have a limit for overtime?
No, it should be practical. Whatever you are saying as overtime, it should be practical. So you cannot say that the person is working 160 hours per week.
So in this case, like no need of concurrent H1.
Well, you need concurrent H1B if the person is working for another employer, right? So concurrent H1B is needed if a person is working at two locations, right? So if a person wants to hold two H1Bs, then one will be the primary one, the other one will be a concurrent one.
So in this case, like if the person is working with multiple projects, so
Is it through same employer or different employer?
same employer.
If it's through same employer, no need to file concurrent H1B.
Okay. And
If it's through different employers, then only you file concurrent H1B.
rest of the hours we can keep as overtime.
Yeah.
Thank you.
And for that overtime, should we justify like by submitting? If they ask for any timesheets or anything, will they
No.
ask for it?
No, it's the employer. The employer has the liberty to choose whatever. For example, assume that you are billing 40 hours to the client, right? But maybe he is doing some admin work also wherein you have to pay him for 10 hours extra. That's perfectly fine.
And if the person is on full time, can he work with a different employer? I mean, apart
Yeah.
from concurrent.
So, for example, if a person is working part-time or full-time for one employer, right? You can always work for another employer using concurrent H1B, right? And that concurrent H1B could be for a part-time position or a full-time position.
But we need to have concurrent for sure.
Yeah. If you have, see, at a time, you can only hold one status, okay, on only one primary H1B. If you want to do the other one, then it has to be concurrent H1B. Does that make sense?
And the concurrent can be no need of part time, right? It can be 40 hours.
Full-time also, yeah. We file concurrent H1Bs for part-time positions, full-time positions, and range of hours, all three. You can even file cap H1Bs for part-time positions. I know a lot of people don't do that one, right? But you could actually file cap petitions for part-time positions and also for a shorter duration. So for example, if you have an internal project, right? Instead of stating that you have 40 like work available for 40 hours, and that too for 3 years of duration. If you have work available, like if you have enough work for only 20 hours, then you can mention that the beneficiary will be working for 20 hours per week and for maybe 1 hour, 1 year, or even 6 months. So right, this is especially true if you want, like for example, if you have a short-term project wherein you hire a candidate to work on your internal project for maybe 6 months, and later on you want to move them to a different client or whatever, right? In those cases, it is better for you to provide correct information stating that the beneficiary will be working only part-time or full-time for only 6 months, right? That way you get the H1B, and later on, once you find, if you want to move them to a different client project, you can file an amendment. That way, you're not providing falsified information to your CIS. Okay, but a lot of employees, what they do is they just file H1B using in our project for 40 hours, and then they'll say that the project is for 3 years, right? And then they place them at a client project. That is illegal. That means you are providing fraudulent information to your CIS, or you're misrepresenting yourself. Is that clear?
Sir, in Corona time, I'm now also one of the consultants working on 2 projects, and salary is more than 200K. Is it going to be red flag or?
No. So what you do is you pay them as I mentioned, right? It's perfectly fine for them to work on multiple projects. You pay them the regular wage as per the LCA. Then have a next line item that pays them for the overtime. Yeah. Not necessarily, but when you're filing for H1B extension, right, to the primary employer, at that time there will be a question asking for provide the most recent H1B petition receipt notice number, right? Again, here we have to look at the employment agreement also, because most of the employers, they have a moonlighting clause in their employment agreement. So if an employee is actually working, even if they're working using under H1B, and if they're violating that employment agreement, they could be sued for that. I'm sorry.
In terms of employee perspective,
Mm-hmm.
is there any risk if
No.
we go for concurrent?
No.
When filing for green card?
No. That's perfectly legal, and it's allowed by law. So yeah, there's nothing to be worried about.
Sir,
Well, as long as it's not a violation of his employment agreement, which is fine.
so
Right? That has nothing to do with this immigration thing. It has to do with more of contractual thing.
So while going for concurrent H1, do we need to maintain the wage levels?
Of course. It's the same thing as filing a fresh normal H1B.
Sir.
Yeah.
So while we are paying the additional wages overtime, so what if the times are not matching the actual hours? So they'll be working as per the actual hours, but we are paying as overtime. So, but for that overtime, will not have the time checks, right? The hours will not matching, right?
That's what I mentioned, right? So the hours need not match, because the hours that you submit to the clients to the client is different from the hours that you actually receive.
Okay.
I'll give a small example, right? So assume that I have placed one of my employees to work for Apple, right? He's working on the project. While working on the project, he has to attend client meetings with me also, right? Our internal discussions, everything. So maybe he's submitting 40 hours timesheet to the client, but when he's submitting timesheets to me, he may be submitting 50 hours because he's working on other things for me. Similarly, maybe he's working on that on the client project, he's working for 30 hours, but I am also putting in some of my time, so I could be billing the client for 40 hours.
Got it. Right. And regarding concurrent H1, I have one more question.
Yeah.
So, we have an employee that who is requesting for the concurrent H1. So, when we file the concurrent H1, so one of the petitions approved will be the second employer, right? So, the concurrent employer.
Need not be approved once you file it.
Okay. And what if the actual H1, the primary H1, that employer, what if he revokes his H1?
Then you have to amend your H1B.
So we need to amend it.
Yes.
Okay.
So I'm gonna like, since we are on the concurrent H1B, I'm gonna give you another thing, tell you another thing. So you know that there are a lot of cap exempt employers, right? Okay. So typically, if a person's H1B doesn't get picked up in lottery, right? So they can work for cap exempt employers. So cap exempt employers are the employers who can sponsor H1B without having to go through the lottery process, right? So most of these are like non-profit organizations or research organizations. So good thing is if a person is working for these non-profit organizations without having to go through the lottery process, at the same time they can file a concurrent H1B through an IT consulting firm also. Does it make sense? So assume that I like my H1B petition did not get settled in lottery, right? Then I choose a cap exempt employer and they may be paying me very less amount of salary, but they'll be able to sponsor my H1B, right? Without having to go to the cap. With that H1B, I can work for another regular IT consulting firm using concurrent H1B.
LCA is mandatory
Huh?
for a concurrent visa. We need to file a LCA as well.
Yeah, same thing as a regular H1B. There's no difference. Okay, but you could be using the concurrent H1B as long as the initial, like actual H1B is valid. That's all. Okay. So in this case, as long as I'm working for that non-profit organization, I can continue working for this IT consulting firm using the concurrent H1B. Is that clear? Let's go to the next one.
Sir, yeah, waiting for a minute. Yeah, one particular location, second level wage is 120K, and if my location changes to California and my wage is 140, how do employer manage it if he cannot pay that salary? Can we decrease the pay?
You can decrease the pay, but you need to change the job duties too. Okay. And you can play with the job duties, right?
Can change the wage level from like 3 to 2?
Oh, of course. We actually received a RFP like just like so the employer exact same scenario. So the employee actually moved to California, right? Yeah. So he moved from somewhere to California. So and then they were about to file an extension, amendment plus extension. So we had to change it from I think level 3 to level 1 or something like that, and got approved. There was an RFP, but we had to justify it. So it is not about what the beneficiary's qualifications are, it's about the position requirements.
One more. So for part-time cap, if you file a part-time cap H1, so what would be the wage level? It would be 50% of the original LC? Or
No, so what you will do is you'll mention the hourly wage.
okay.
Like whenever you have the prevailing wage, right? There's an hourly wage also. You'll mention the hourly wage per time of filing the LCA as well as the H1 petition. But make sure your employee is not H1B dependent or a willful violator. If they are, then make sure you're using it for an exempt position wherein the beneficiary has a master's. If you have none of these, then make sure that your wage crosses the 60,000 mark.
So
Because if you
it is
don't do that
mandatory.
one, then you have to do the complete recruitment for filing this H1B.
That is all. If the wage level is getting decreased, then anyone can file as a part-time cap.
Oh yeah. So that's what, if you plan it properly, you can do it. We file many H1Bs for part-time positions, but it has to be properly planned. So for example, if the wage is $30 per hour, we need to make sure that if, $30 per hour, 60, right? If the wage is $60 per hour, right? And make sure the person, like you mentioned, at least 20 hours per week. If you say 15 to 20 or 15 to 35, then then you have to do the recruitment. Okay, let's go to the next one.
Sir,
Uh,
like, yeah.
oh, sorry.
Sir, there is an employee, like, he's on H1B, and now he got his GCEAD. So when we can run his payroll?
Whenever, so all you got to do, you can run his payroll whenever you want. Like as long as he's working, you have to run his payroll, right?
But we haven't withdrawn his H1B yet.
Huh?
We haven't withdrawn his H1B yet.
Okay, so the best thing to do in these cases is, once a person gets his GCAD, I highly recommend that you update your I-9 record so that you move to GCAD. Lot of employers are not doing that one. If they don't do it, then you're still held liable as per the H1B regulations. Once you move them to GCAD, withdraw their H1B.
Like he received his card on like exception as November. We run his November payroll on H1B.
Whether you see, it's the same payroll whether you're running it on H1B or GCAD, right? It doesn't. There's no difference in that.
Like for H1B we can pay in LCA wages. For GCAD we can pay in hourly basis.
Okay, so that's why, if you are trying to make that change, make sure to clearly move them from H1B to GCAD. Document it. Document it. How do you document it? You'll update the I-9 record, right? You'll also inform your CAS that you're asking them to terminate that H1B. Right? So now the beneficiary can continue working for you using his GCAD.
Is that a problem? Like if he's still running his payroll on H1B, like after
No,
becoming
no,
GCAD?
no, there's no problem with that. Because he can be maintaining his H1B status as long as he wants to, right? Okay. So now we get to the important topic, which is collecting the money. How many of you have issues collecting money from your vendors? Good. You're having issues. Okay. So whenever you sign an agreement with a vendor, what is the first thing that you need to do? Huh? Payment and terms. Okay. Okay. I'm going to give an example. Okay. Assume that I come up with a company called like Santosh Cart, right? And I say that, hey, I'm going to enter the contract with you, supply all your resources to us, right? And then we enter into a contract. So what is the first thing? How do you do your due diligence? What kind of due diligence do you need to do? And this is one of the biggest mistakes that I see that a lot of accounts team make. Huh? Forget about all that stuff. Just reviews, right? Okay. How do you check the review? When you say review, you're right in a way, right? But how do you check? How do you get the proper information about that client? Huh? Glassdoor. Okay.
Best business practice.
Next.
Yes, business practice. Best business bureau is there.
I'll tell you something. Typically, if a vendor stops paying one client, they'll start paying other clients too. Right? That is what exactly happens. So the best thing for you to do is, whenever they send you an agreement, right? So it will state the choice of law, venue, as well as their address, right? So for example, assume that the vendor is in some Maricopa County, Arizona. I'm just taking it for an example. First thing that you need to do is go to Maricopa County court website. Okay, look up if anyone has filed any claim against that company in that courthouse. That is the best way to find out if this is a troublesome if this vendor is a troublesome maker. Okay. Similarly for employees also, if you want to make sure like you work for an employer who doesn't always go after the employees suing them, the first thing that I would do is, if I were to be an employee, I would go and look at the county court website where the employee is located to see if the employer has filed any cases against the employees. Okay, does it make sense? If I come across an employer who has been filing cases against his employees like regularly, then I will not join that employer in the first place. Similarly, if I come across a vendor who has a lot of cases pending against them, I will not work with them. Yes, it will be available. You just need to do some research. Okay, and that is what of, like, for example, if, and then make sure that the agreement is reviewed as per that particular state law, right? So when we are checking that one, we also check to see if there are any cases pending against that company. Right? Also, whenever you have a situation wherein you did not receive payment for more than what once they violate, for example, if the payment term is 60 days, you don't receive this thing, make sure to send them a demand letter to letter. Okay, do not contact the client directly, because what happens is a lot of these vendors, they have clause in the agreement which states that you cannot contact the client for whatever reason, right? Whether it's payment or whatever. When you try to contact the client, then they will use it against you for damages. They'll say that, hey, because of you, yes, we're gonna pay you this money. That's separate, right? And then they'll have a degraded damages clause for any damage that they have suffered. Now they'll say that, hey, since you reached out to the client, we are incurring damages, so we have to pay those damages. You cannot argue that, hey, since you did not pay, we reached out to the client. That doesn't make sense. Because if you argue that one, the court would say that if you did not receive the payment, then you should have proceeded against them legally. But you didn't have the right to contact the client regarding it. What's that? That's a problem. That's why initially itself I told you, right? Make sure you have an indemnification clause in the agreement, and also inform the employee that you should not be doing that. Directly or indirectly.
So let's say employee is working for the vendor and without the employer's knowledge, if he exits, like he resigns and doesn't want to work with the vendor, still employer has the flexibility to reach out to vendor and get the amount, right?
Of course, the employee has nothing to do with this. That's based on the agreement between the employer and the vendor. Okay, whether the employee is continuing to work for the employer or not doesn't make any difference. Since they have provided services, they have to get paid for that. Period.
Thank you.
Okay, so whenever you have a situation wherein you did not receive payments for, like, once the due date has passed, make sure to send them a demand letter. And also periodically check the court website to see if they have stopped making payments to other vendors too. If they did that, then maybe you should just stop working with that vendor. Because usually what happens is they'll say that you receive payment for 2 months, 3 months. There are a lot of people who lost money because of this. Right? That's a problem. So even if the employee goes and talks to the client, right, they will sue you for that reason. That's a problem. There are a lot of employers who are going through this. And litigation, the problem with litigation is it's not about who is correct. Okay, it's about who has deep pockets to spend on attorney fees.
What is the call? So what should we do? Example, I have a case. Say the vendor is not paying me from August, but I'm running my consultant payroll. So
if they're not paying you from August, then you have to send them a demand letter.
we already sent, but they're not replying.
Okay, where is the vendor based out of?
California.
Good. So in California, there is an option for the employee to go against the client also, client and vendor. That's only applicable in California. So in California, if an employee is not paying, the employee can file case against the employer, the vendor, and the client also.
Yeah, my consultant has approached the client, but these vendor came to us saying that you are breaching the contract. We'll sue you. Some like for
You don't want to do that one. That's why you should send them a demand letter.
Yeah,
and
we
then,
already sent a demand
okay,
letter.
then you
but,
should stop working with them, stop providing services to them, and then file a lawsuit in the court. Because if you reach out to the client, then he can have a claim against you.
yeah, thank you.
Go ahead.
Good afternoon, everyone, as well as Mr. Center. I'm Sparina and I'm representing Synesis. So I have a quick question. In the agreement, if at all we have this clause, that if at all there is any clause, the agreement itself is null and void.
Typically, they would not allow that clause.
If at all it is allowed in that case,
So you're saying that, okay. So you're saying that the agreement would have a clause stating that if one of the parties violates breaches the contract, then the whole contract will be null and void.
yeah.
Usually, no attorney would want when for example, if I am sending the contract to you, I would never allow that kind of clause in it, because typically what they would do is they'll say that, hey, even if one party breaches the agreement, it doesn't mean that the other party can breach it, because 99% of the times the vendor will be breaching it because they will not be paying you on time, right? So once they know that once they don't pay you on time, that's a breach of contract, and that you will just you'll breach the non-association non-compete clause too.
Exactly. So if at all that clause is involved, then we can go
Well,
ahead
yeah,
and
if you can get that clause into the agreement, yes, you can do that.
sounds good.
But
And,
usually, none of the vendors would allow that.
and there is another alternate option which I come up with. Can we confirm them through the mail officially that since there is no response from your end and the leavers no chance but to approach the client and take it officially,
No.
we are giving the
No.
notice?
No, you have a choice. There is no this thing of not having a choice, because you have the choice of suing them in the court and getting the money.
So the only option is to have a clause which is involved that it is
Yes.
mutually applicable for both.
Yes. Or have a clause in the in the agreement stating that they would allow you to actually reach out to the client in case of the payment delays. But typically, they would not allow that to be there.
Thank you.
You're welcome.
What are the major points we have to check in MSA before signing the contract with vendor?
Good. If it's a vendor contract, okay. Who has bigger chance of suing the other party in a vendor contract?
Vendor. They say it's their MSA, so they have more authority.
No, not the authority. Who has more chances? So the vendor can sue you only if there is a breach of non-compete non-solicitation clause, right? But typically, you would be suing them if they don't pay you, right? So depending on because that's when the contract will actually get into picture, right? Either the vendor did not pay, or you breach a non-solicitation non-compete clause, right? So depending on that situation, you have to see whether arbitration is a better option, or being able to file in the court is a better option. That's one thing that you have to look at. You have to look at the state laws and the payment terms, and also any clauses that will unduly restrict your ability to collect money from them. Actually, there are a lot more things that you could actually look into. But if you send me an email, I'll provide you that information.
Sure, sir.
Because I want to get to the H1B modernization rules, because I know we have very little time, right? Next. I think I already went through the ability to pay, but okay. If you are sponsoring any green card applications, please do not show losses. Please do not show losses. I recommend that at least showing some profit, unless you are a very big company with more than 100 employees. Okay. Actual cash basically one of them. Okay, so make sure, like, if you want to get the best value for your company, I highly recommend that you audit your books from time to time, not only like your accounts, but also your legal, like for all your legal compliance too. I think. Go to the HMB modernization. how many of you are familiar with the H1B modernization rules? Good. One, two. Anyone else? Okay. I highly recommend that you all read those regulations. It's very important because they are going to go into effect Jan 17. Okay. Even if the Trump administration wants to make any changes to that one, they cannot do it for the next at least 1.5 to 2 years because they have to go through the regulatory process and all that stuff. Or, but I don't think they'll be doing it through the legislative process. So these regulations will stand for the next 2 years at least. Okay, so it's very important that you have a clear understanding about the new H1B modernization rules. So these regulations will go into effect on Jan 17th. So any petition that you file after Jan 17th, they will be reviewed as per these regulations. But recently we already been seeing some RFPs issued based on these regulations, although these did not go into effect. So these regulations primarily affect H1B workers. But apart from H1B workers, it does affect other visa holders also, like H2Bs, TMs, E3s, and all other non-immigrant workers too. So in this one, let's go to the CAP registration process. Okay. So the CAP registration process pretty much stays the same as it did last time, which is beneficiary centric. So no matter how many number of employers file H1B CAP registration, will be selected as only one slot. Right, and also in this one, they clearly mention like, so even if multiple employers submit CAP registration on behalf of the same employee, right? I think you have been receiving a lot of noise on that one, right? Actually, as long as you can prove that these are for separate bona fide job offers, it is fine. Okay. That's it's called matter of S. You could actually look it up online, wherein the court has clearly mentioned that as long as they have separate bona fide job offers, you should be fine. But proving that you have separate bona fide job offers will be a challenge if these are rated companies. Okay, so I highly recommend that you do not submit multiple registrations to different companies. Is that clear? Does anyone have questions on the H1B CAP registration process?
So when you said related, it means like there should not be any MSA in between those companies.
Not MSA. Well, even if MSA also we could say that, for example, assume that your company ABC Corp, and then you work with a vendor, maybe like small vendor, right? Some smaller consultancy firm, and then you got the H1B, both of them file the CAP registration, and then you use them as a vendor. Yes, it shows like as if both of you are filing for the same position. That's a red flag, right? But what is the advantage that you're getting by submitting multiple registrations in this case? There's no advantage, right? So stick with submitting one registration per candidate. Okay. Also, the H1B CAP period need not start from October 1st. You're all familiar with that, right? Same thing as last year. Next one is expansion of CAP rules. So usually CAP is allowed only until October 1st, right? Until September 30th. So if a person has a pending H1B petition, CAP H1B petition with USCIS, and if they have requested for a change of status, the person can continue working using CAP OPT until September 30th, right? Now they are allowed, because of the delays in H1B processing time and all that stuff, they're allowing them to get CAP OPT until April 1st of next year. So that will allow a person to continue working for much longer time using the CAP. This is one important thing. Now under this, they're going to give deference to the previous approvals. So if you have a H1B that is already approved, and if you're filing for an extension with no material changes, right, they have to give deference to the old approvals. During the Trump administration, they actually changed it, right? So they mentioned that they will not be giving any difference to the old approvals. But now in this one, they clearly mentioned that difference will be given to the old approvals as long as it was not approved by mistake. So now we can expect a little more consistency. So elimination of itinerary of services. Now you no longer need to provide itinerary of services. So non-speculative bona fide employment. This is where the challenge is going to start. So now, until now, you could get H1B approvals even without providing an MSA, purchase order, client letter, anything, right? But with this one, now you're required to prove that you have a bona fide job offer available for the candidate. That means you have to show that there is non-speculative employment available for the candidate. So you'll have to provide MSA, vendor letter, MSA, purchase order, vendor letter, or whatever is needed to prove that the work exists for the candidate. Okay, so it's like just going back to the old times wherein you're required to provide all these documents. Not only that, whenever you have a third-party placement, in order to prove that position qualifies for specialty occupation, right? The job requirements have to come from the client. So basically, they're asking you to provide the client letter, right? Or something from the client to show that these are the requirements from the client. So here you'll be encountering two challenges. One is most of the clients, they will not mention that the position requires a bachelor's degree, right? Even if they mention bachelor's degree, they will not mention which field they need it, right? They will not mention that bachelor's degree in computer science is needed. Assume that they mention that also. Along with that, they'll also mention that the position requires 5 years of experience. So once they mention that the position requires 5 years experience, now you're providing that information to the government, right? So they will want you to pay level 4 wage or whatever. Okay, so basically we're going to go back to the old times wherein we need to provide the client letter, the vendor letter, or MSA and purchase order. That will be the biggest challenge. The next thing is with FDNS visit. As I mentioned initially, right? Until now, if FDNS visit is, compliance with FDNS visit is voluntary, right? But now they're going to make this mandated, wherein if there is an FDNS officer who visits your office, and then if they want to get some information, you have to provide that. If you don't provide that one, they can withdraw the H1 or deny the petition. So this is another challenge that you'll be facing under this one. Redefining specialty occupation, actually they have slightly modified the definition of what qualifies for specialty occupation. I don't know if it's worth going through that now, but the most important thing is that for third-party placement, they want the position requirements to come from the client. Does anyone have questions regarding this? So, incline. So if you're placing a candidate at Apple, they want the position requirements to come from Apple. That is going to be a problem. Yeah.
So when we speak about gap rules for an OPT consultant, as you say that until April 1st, we're not required to do change, right? Because we have already applied for H1B nomination. What if it is getting expired before the nominations? I mean to say, he need to file for his extension or not? OPT extension is required or not?
I didn't quite understand.
Gap rules. When we speak about gap rules, until April 1st, the candidate can be on OPT, right?
Yeah.
His H1B is submitted.
Yes.
Because he has to wait to get the approval. I just want to understand before 30 September if his OPT is getting expired. In this case, does he need to apply for extension or it's not required because
No, he will get the cap. They will provide the cap.
Oh, no need to file for extension,
No.
right? Thanks.
Sir, now in this coming administration, does ITSO memo going to sustain or it's going to be into trash?
Well, with this modernization rules, it's already in trash, right? Because except for the right of control, right, and the H1 3-year H1B approval note period, right? Now they have to prove that there is a bona fide job offer,
Yeah.
non-speculative employment. The client letter requirement is going to again start. It's going to be a challenge.
Got it, sir. Thank you.
No, these regulations will affect after Jan 17th filings or like the one which we filed before as well.
Usually it should go into effect after Jan 17.
And do we have any changes for amendments as well? Like from day one, we have to file the change of location or the
It
pay.
remains the same. I think so. I don't have. I think they already updated the registration fees. They have increased the registration fees. I don't know the exact number, but it's 200 and 250. Yeah, it's 250. Any other questions? So now tell me how many of you think that the business is going to thrive during the Trump era? Good. That's true. So we could have issues with the wage levels, right? Maybe he'll ask, like they might come back and say that, hey, you need to pay higher wages. But based on the recent news, it looks like it's going to be favorable for the H1B workers. So the business is going to be good. But of course, the laws will be implemented more strictly now. We can expect more FDNS visit, more RFEs. Okay, even denials could happen, but still you will be able to run your business. What's that? Yeah.
So, I have one. For a person who is working in hybrid with the client place, and what if he's not in the office if officer comes as a site visit?
That's not a problem as long as you could, like the officer is able to reach you, and if you can tell them that, hey, I work from my work involves hybrid, right? And then you're working from home on that day, that's perfectly fine.
If a person is working remotely, like 100% remote job, where does he need to post the job postings?
Wherever he's working from. So if he's working
At
from
his
home, he
home.
will just post it at his home.
Like onto the door, onto the main door, or the workplace, or where exactly? Like
On his refrigerator.
Like normally, if a case gets approved in the consular processing, should he need to travel out of the country, get his like go for the stamping and come back to the US, or
Not necessarily, like they don't have to do it immediately, right? If they already have a valid visa, or like for example, the person is already on OPT, he can continue working on OPT, and whenever he wants to get back to H1B, he can either go for stamping, right? Or he can file for another H1B with change of status.
so without even working on this H1B,
Yeah,
can he
they
work?
can do that.
Can he change for
Yeah.
file for change of
Yeah.
status?
But there is a risk here, right? So for example, if once H1 petition gets approved, right, there could be a site visit at any point of time.
Okay.
Right? If the person is actually not working in that position, then they might withdraw the H1B. Right? And if the officer doubts that the position did not even exist at the time of filing the petition, then they may withdraw it for fraud or misrepresentation. If a petition is revoked for fraud or misrepresentation, then the cap number will be recaptured. So the person will have to go through the H1B cap process again.
Okay. Yeah. For the consular person, should he go to the home country or
Not
just out of the, any
Not
other
necessarily, but home country is always better.
country? Okay.
Good. Any questions? I know it's
And
more
one
management
question
on
on behalf
Yeah.
of many companies. One of the major election promise Trump has made is anyone with a US master degree will get a green card. So do you think that is possible?
It's not technically possible because the number of visas that are like that the green cards can be issued is limited to 140,000, right? And over there we have the per country limit and everything. So it's not possible to issue green cards for everybody who has a master's degree. But they might come up with a procedure, like for example, EB1 category or something like that, so that people who graduate from top universities could be eligible for that one. That's one way of doing it, but I don't think he's going to give green cards to everybody. That's not practically possible.
Thank you,
So on
sir.
one hand, we're talking about people getting green cards. Other hand, we're talking about people not getting even OPTs, which doesn't make sense, right?
Yeah. And one more commonly asked question is, lot of the firms and there is a lot of panic in the market about traveling before January 20th or immigration related panic after January 20th. How do you see this?
I would not worry about it too much. I know everybody is talking about, everybody's panicking, but it can last. Like whatever that decision that he's going to take, it has to be probably staying for 5 years, right? And I don't think it's practically possible for anyone to stop traveling for 5 years. Of course, since we don't know what kind of restrictions will be there, it's better to avoid traveling after Jan 20th for a few days to see what kind of decisions they would make. But for H1B workers, as long as you have a proper job, everything is proper, I don't see a problem. The same thing applies to students also. As long as they are not violating their status, getting their studying properly and everything, I don't see a problem.
Thank you, sir. One more question. During the last term of Trump, we have seen several travel bans imposed on specific countries. So would that
That
repeat
could be
again?
there.
Yeah.
Because that's part of the executive action, right? So, yeah. So we can do whatever. Like, yeah, that's
Do you foresee a faster progress in the movement of employment-based immigration numbers due to a drift travel bans from family-based immigration?
well. If they make it a little tougher for the family-based immigration, then definitely yes, it's going to be helpful for the employment-based, right? So, like during last time also during COVID, right? A lot of embassies were closed, so they were not issuing GCs, family-based GCs. That's why there was a huge overflow of family-based green cards from family-based to employment-based. That's why a lot of people got their green card, employment-based green cards.
Okay, sir. And how is it gonna be at the consulates? Like we have seen a lot of 221Gs since the last few months.
That will be there. So we can expect more 221Gs, more scrutiny. Okay, but as long as you are maintaining the person is maintaining his status and there is no fraud involved, they should not be worried about it too much.
Okay, sir. Thank you.
So there was one scenario with one of the consultants. He was having a valid H1B. He traveled to India because of some emergency, and he was in India. When he traveled for stamping, he got to know that his H1B was revoked. When he inquired with his employer, did his employer withdrawn the petition? Then the employer said that the H1B was never withdrawn, and the reason he got to know that before that he has applied for multiple registrations, and because of which his H1B was revoked. So I just want to understand.
His H1B would not have been revoked without the employer knowing about it. The employer would have received a notice of intent to revoke before they revoked the H1B.
So it is not an impact of multiple registration, right?
No. Even if it's because of the multiple registration, the employer would typically receive a notice of intent to revoke, and they will give him the opportunity to respond to that one.
So coming forward, we can expect that the people who applied for multiple registration.
Oh, that has already been there. Like a lot of people who submitted multiple registrations, they're receiving notice of intent to deny, and the petitions have been revoked. So if it is revoked for this reason, then the cap number will also be recaptured. So they cannot file a H1B transfer to another employer. They have to go to the cap process again.
Again, they have to apply
Yes.
for lottery process,
Yes.
right? Okay, thank you, sir.
Yeah.
So, recent times we have filed few cases on our own personal projects which we have at our own office. And we see the cases which are not being approved
in spite of having our own genuine projects. And what exactly could that be the reasons? You know, we see without any reason.
Because
we
of
get
all
that
the
point.
fraud that's happening here.
No,
Okay.
there was all a genuine project. Everything was all on set, and we had everything that could be shown.
Okay. So typically, there is a red flag whenever an employer moves the employee from the in-house project to client location as soon as they enter into the US. Right? I don't know if you had similar kind of a site visit, and if they have realized that the employer is actually moving the candidates as soon as from the in-house project to the client location, as soon as they enter into the country, or if nobody is working on those projects, then yes, there could be any issues in getting visas for those positions.
We used to do, but not very soon. But you know, maybe a year or so. Would that
Year or
still-
so. So did you file H1Bs for that 1 year period, or did you file it for 3 year period and then?
3 year period.
That's the problem. Like, that's what I was telling you. If you believe that you have the work available for only 6 months, file the H1B for 6 months. Right? That means you've been truthful to the officer. But if you're saying that you have project for 3 years and then just automatically changing it, moving them to different clients, then it's a problem.
At port of entry, after Jan 17, do they ask for client letter for the new travelers? Any chance?
They may not ask for the client letter, but they will ask for the employment verification letter. Okay, and they might also verify, sometimes they may call the client to verify they actually have a project. It is possible, but it's very rare.
Because if we keep like either in-house or then they might be asking for only employees.
They'll have more scrutiny, they'll scrutinize them more.
So in this case, like it's
Usually the officer at the CDP level, he will not have access to the petition, unlike the officer at the visa consulate. Any other questions? Good. Thank you all for attending this event. Thank you, Raga. I hope it was informational, and thank you for spending time over the weekend with us. And if you have any further questions, please let us know, and I will be happy to help. Oh, you want to take? I don't know how long is. 4 o'clock. Oh, you have time? Okay. Good. Good, go ahead. I know, feeling a little bit like huh? Uh-huh. Online filing. Huh. Okay, so I think one of our employees can speak better about the online filing because they do it. Can someone go like speak about it? It's pretty simple, right? It's actually better to do online filing because you're able to get the receipt notice immediately, and then you have better tracking and all that stuff. And approvals are also coming much quickly if you file it through online portal.
It's such an informative session this morning. You've been standing and sharing all the knowledge. What is the outcome? Is there any way that we can utilize your services, or somewhere we can reach out to your desk?
Definitely. The best way to reach out to us is by emailing us. Our email address is info@someridila.com, info@someridila.com, or some of our team members are here. You can contact them. They'll be able to get you in touch with us.
Sir, I would highly recommend you to take another same kind of session after 6 months, probably in July, so we can have more questions.
I'm planning to do one right before the cap release because by then the Trump administration is going to office. Like we'll have a better idea in the next one and a half month. In the next 1.5 months, we'll have a better idea. But at that time, I'll probably do a session just on immigration, like because right now the topics that I've covered are more applicable in general, right? Whether it's Trump administration, Biden administration, whoever it is in office, right? So the next session would be more specific to just H1Bs and green card process, just primarily immigration. First of all, yeah, well, we are actually moving our office here. So until that construction is completed, I'll have to be here for the next few months. Yeah. Yes, will answer.
I would like to give thank note here, Mr. Santosh here. I think this is the first session in Hyderabad an immigration attorney is conducting this kind of session. So, yeah, we are thanks. I mean, like, thank you so much.
Thank you.
Can I go ahead? Yes. So can you brief a little bit on the counselor H1, please? The checklist that was asked to follow or get points that you need.
Good. The first thing is make sure before your employee goes for H1B staffing, right? They have to thoroughly review the LCA, review the support, like the I-1 vendor form and the support letter writing the services. Lot of times, employees go attend visa stamping without even knowing about the information that's presented in the petition, right? So it's very important that you not only give them a copy of the LCA, but also provide them with the itinerary of services, the job duties that they'll be performing, the client, the project that they'll be working on, all that stuff. Okay? Because typically the officers make a decision within a few seconds. As long as they can see that whatever the information that the beneficiary is presenting matches with the information in the petition, there is a high chance of getting visa approval.
I do have few more to go ahead,
Sure.
if you don't mind.
Yeah.
So initially we have discussed about the RTR clause and all that needs to be taken from the candidate, including exclusivity, right? So it's not mandatory that the candidate whom we are going to submit is supposed to be only for one client. It could be multiple clients. So each and
So
every
if you have it for multiple clients, make sure you have it for multiple clients. Okay? It's very important. Because if, for example, if you take my resume and if you say that I'm going to submit to clients, I'll be working with multiple employers, right?
not the employer, but the clients that we have the position within certain clients.
That is true. I highly recommend that you clearly mention who the.
Is there a chance where we can bind them with exclusivity clause that certain period you are
You cannot bind them with exclusivity clause for any client that their employee is not aware of, right? If you're binding in that way, then you have to at least put them on wage because now their life is restricted.
And also what
If they are your employee, yes, you can probably do that, but not for someone who is just applying for a job.
and what about the fines or any clauses that would be applicable to us through the vendor or client? Can we pass on the same clauses to the candidates as well in the executive?
You can do that.
That also includes a level of fine and all.
Yeah, yeah.
And
That's the indemnification clause.
do we have any certain limit for the fines or penalties that's supposed to?
Best thing to do is just put in indemnification clause stating that, hey, whatever the damages that the company incurs because of the beneficiary's action will be transferred to the beneficiary. Just put in indemnification clause, that will solve the issue. You don't have to mention any specific amount for that.
And also you mentioned that we cannot find the California candidate, whoever is actually employed.
Well, in California, you cannot use the non-compete clauses against the employee.
What would be the ultimate option?
It's not. Yeah. If an employee comes to me saying that, hey, Santosh, I'm working for so-and-so client, now I want to breach this non-compete non-solicitation clause, what do I do? And if I can tell them, hey, move to California, make sure to inform your employer about it. And if they file an amendment, that means they're attesting to the fact that you're actually a resident of California. And now you can just move on.
How far can we
That's perfectly fine. Digital is fine.
compare it with the
Not necessarily. It's So when you have the, like, if you're using, I'm assuming that you're using Adobe Signature and all, right? You should be fine.
Also, how far legal aspects when we have to deal with any candidate related failures or
You could, like, you could send them a demand letter, or if you can file a case against them. But I highly recommend try to avoid going after the employees as much as possible, because you're going after a small fish,
how
right?
highly
At the same time, yes, everybody has to do your you have to do your business, but keep it reasonable.
how highly status when the candidates after all this changes?
I highly recommend taking H1B candidates.
Thank
If
you.
you're not able to find a US worker,
Got it.
right? Because if you are able to find a talented person who is only an H1B, then you don't have an option.
And is there any chance of where we can able to revoke someone's background check after getting interview? If at all there is issues that goes on with the candidate.
Yeah, if because it's all at will employment, right? You can always fire the employee for any reason or no reason, right? But once you file a H1B, then you're kind of stuck. You have to properly terminate the candidate.
Not for the background check.
Yeah.
When we do the kind of as small
The problem here is the employee, the person can have a claim against you if that information that whatever you're providing is incorrect, right? So you have to be very careful when doing that.
Yeah, thank you.
That's why even if somebody leaves your company, right, and if somebody is calling to get a verification letter, they would they would not ask you whether you, how is this person. Instead, they would probably ask you, are you willing to rehire this person in the future? So if you say no, that means there's something wrong with the candidate.
So, for this for this new cap, is there any change in fees for registration at the
Yes,
same time H1?
yes, yes. We just talked about it, right? I think they are increasing it to $250 for the cap registration.
250 for the registration. And what about the filing?
The filing fees will remain the same, whatever is the current filing fees. They already increased it recently, right?
Thank you.
Sir.
Yeah.
Madhu. Sir, for example, we just started the company in US. We do not have any tax returns or anything done, and we have like 5 or 6 H1s paid. How do we prove our financials, or what are the complications as an employer we might have to face?
Good. First thing, if you're H1B employer, right, you need to show that there is some supervisor in the company, right? There should be at least 1 or 2 employees in the company. I recommend having at least 1 or 2 employees in the company before you start filing H1Bs. Okay, one of the employee could be the president of the company. That's perfectly fine. And then also, now you're stating that you'll be paying maybe 100K or whatever to the candidate, right? So you need to show that you have the ability to pay that one. So if you already have in business for quite some time, if you are generated at least 100 200K in revenues, then it's clearly evident, right? Along with that, you'll also provide the MSA purchase order to show that there is actually work available for the candidate and that you will be generating enough income to pay him, right? So typically, I recommend that you have at least 200K or 50K in revenues and 2 employees before you start filing the H1Bs.
One more. Can the signing authority be out of the US, like, in subsidiary company for example, in India?
As long as they are authorized by the company board owners. So now they're going to go after the owners of the company.
Thank you, sir.
Okay?
Thank you for this
And also,
opportunity.
please be aware, now the government is requiring everybody to provide the beneficiary ownership information for all the companies. Because it's a different entity, right? The entity filing the H1B is the US entity, which is separate from the Indian entity. No. So you usually, okay, if you do not have it, because some of the companies will not have revenues, right? But they will at least have some assets. For example, if it's a startup, right? Maybe you're building some product and all that stuff, you don't have revenues, but at least you'll have some assets or some money in the bank. That is fine. So if you have, but in these cases, it's little tough. But if you have a project, if you can clearly document that you've been working with the client for quite some time and that you have regular work available for the candidate, then you can make it work. Okay. Well, see, H1B is for a special occupation position, right? So what you're asking me is for it that the person would more qualify for an L1A, right? L1, you could probably try L1A new office. That's the best option.
Hi Santosh, very good evening. So when it comes to concurrent H1 here,
Sorry.
here.
Oh yeah.
So I'm an employee. Working for ADP, and I want to go with an employer. Suppose filing concurrent H1, and I want to work for another client. So will I have to intimate ADP people that I'm going to file a concurrent H1?
That depends upon your contractual agreement, which is the employment agreement, right? So if your employment agreement has any restriction, then you have to abide by that. Usually ADP would have it. At least in your employee handbook, you will have a moonlighting clause.
Okay. So when we are filing LCAs, we have to go back and check the travel histories, travel to other countries, right? So up to what time frame we have to check?
LCA?
Like so amendments.
You don't have to look at the travel history for that.
Okay.
Well, are you asking me about the travel history, like when he like in and out of US?
Yes.
Yeah, usually. So for example, usually for 6 years, okay. But if you're trying to recapture any time, the person, for example, in order to meet the 6-year requirement, then you may have to provide more information.
Okay. So I'm an employer. I have my employee working for full time. Can I pay him on part-time basis?
No.
No. No way. Thank you.
You can pay him, but he can come back and sue you.
Okay. It's if it is an on records also, off records also.
Doesn't matter. Okay, because there is something called circumstantial evidence. They'll be able to get some evidence.
Thank you so much.
Because you'll be submitting client these timesheets to the client, right? Stating that this person has worked 40 hours. Yeah.
Santosh, I just have a small question. Concurrent H1B, right? We have if I am an employee, H1B full time, and parallelly concurrent H1B has been filed with another employer. So in US, does it not fall under the dual employment, or it is
Dual
okay?
employment is perfectly fine.
Okay, perfectly fine. Actually, in India, we don't allow dual employment, right? So I was asking in US, it is okay.
I didn't know that dual employment is not allowed in.
Yeah, two payrolls cannot be run on single entity, Santosh.
Okay. I'm sorry, but I don't know about the regulations here.
So
I mean,
there is
she's
no
asking,
issue of dual employment,
can he
right?
work for 2 employers and 2 roles?
Yeah, as long as you're authorized to work, you should
We
be
are
fine.
not allowed here to work for 2 employees in India.
Then how do people do moonlighting here?
Again, it depends on the company, for the organization that we are working.
Okay.
Suppose in India they work for 2 companies. In Corona time they work for 2 companies, 2 jobs. Like in US, can he do for 2 companies? So he will get 2 W2s or how?
Yeah, he'll get 2 W2. you will receive 2 W2s.
No issues, right? No,
No,
it's not an
no
issue.
issues. You could be receiving more W2s if you moved his employers during that year also, right?
Yes, sir.
That's
And
possible.
Santosh, one more thing. Suppose I-7 ends in valid more than 6 months, but I-94 is getting now. So how can we extend the I-7, I-97 or I-94? Any possibility to extend
To
I-94?
extend H1B I-94, right? You have to file H1B. If you're trying to extend the H1B I-94, you have to file a H1B.
Filing I-94 is manual.
No.
Extension.
Sir, this is out of gratitude. Thank you for taking care of us from morning to till this time. You provided everything free, and we have to be thankful. In this world, nothing is free, but you made everything is free. May God bless you, your team, and may God expand you. Thank you very much, sir.
Thank you.
To add on to the dual employment, I'm talking. So I'm talking. I'm here. Here.
Oh, I'm sorry.
Okay. To add on to the dual employment, it is allowed in India. Only thing is the hours should not clash. That means if I'm working in an office from 9 to 6, after 6 to 10, I can work in another office. That is fairly taken care.
Good. So
That is allowed.
here you're not allowed to work, like you're not allowed to spend 9 to 6 in one office and while in this office work for some other company, right?
Yeah.
That's good.
It is allowed because mainly accountants, they take this dual employment. They work full time in an MNC. As a part time, they work with other companies. If going evening at 6 o'clock, 7 o'clock, working until 10, 10:30 at night, and they get their expenses.
Good. Thank you.
Thank
We can take few more questions. Any immigration related questions or litigation?
I think
related
we
questions?
have, yeah.
We left with 10 more minutes, sir. We can take a couple questions. Anyone? You can
I
raise your
think they
hand.
want to do something else, right? Raffle or something? No, I'm fine. I'm fine. No, no problem.
Yeah, okay.
Anything else?
Hello. Yeah, what will be the timeline process for 221G administrative process?
There is no timeline. Who is asking me that question? Unfortunately, there is no timeline
Okay. But
because we have seen cases that have been pending for under 221G for almost a year also. We could raise request, like sometimes raising requests to a congressman or senator would help, even sending an email would help. But they come back and say that, hey, we are conducting a background check. For background check, they would not give any proper timeline.
if filing in process from India, so in-house filing, so what should be the officer asks for client letter if we don't?
They
have
will
client
not,
letter?
you can clearly mention that it's an in-house project.
So still in-house project mentioned, but they're asking for client letter. How to avoid
You have to clearly, no,
221G?
they cannot ask for. You can clearly mention that it's an in-house project, and these are your clients for the project. Or if it's in the initial phase, then you can say that, hey, we don't have any clients right now, but these are the potential clients.
Okay.
Okay. Okay.
Sir, actually, there's a small game of raffle. Everyone has ID cards, right? You'll have in the last three numbers, like 001, 002, like that. So we'll have three winners. So you only pick it up. That's random. You don't have that. You don't have that.
167.
Is he? He's not there.
If you got a number, you can stand up actually. That way we can identify you.
232.
232. Okay, congratulations. Please come here. Name, please.
A little cheering.
So my name is Sayed and I'm from Response Informatics Limited. I am a BDM and I've been working from past 5 years. And really it was very helpful session for me because I've learned a lot of things related to human resources immigration type. And I really appreciate your efforts. And there is a lot of things that came new into the picture. It will really help us for the upcoming H1B process. And as you have already mentioned that soon we are going to have a new session coming up after the H1B become on. So I hope I will be attending that as well. Thank you so much.
Sajid, please pick your gift.
Before that, please scan the QR code.
182.
182.
182 available in the hall. Okay. He's there. He's coming.
I think this is one way of checking if people are really interested in this session and ended up staying here until the end of the session, right? If he was not there, then I would have thought that only 50% of the people liked it.
Yeah, hi, good evening everyone. Myself Jack, Super Security. I'm a admin feature, so the session was very nice. We learned a lot of things from our local talking. Thank you very much.
Thank you.
One good. Okay. 129.
129. Good. We got other mail.
Good. So based on this, I can say that we have 70, at least 75% success rate, right? Out of 4 people, 3 people ended up staying until the end. That's good.
name is Saichan. I'm from Synergis Technologies. I have 3+ years of experience as an immigration specialist. Really, this session helped me a lot of things, and I hope it will be helpful to immigration process and fighting. Thank you.
Thank you, Saij.
Thank you, sir.
Thank you everyone for attending today's seminar. We have a tea break actually. So we have a high tea. Have it and then we will assemble back. You know, anyone want to personally interact, attend Santosh, you can talk. Yeah. We also need a
No,
video
no more
testimony.
presentation. I'll just sit there and talk. It's okay with you guys. I'm already exhausted. Maybe it's because of the jet lag or whatever.
Yeah. Also, we need a group picture. So,
And also, I would like to thank all our team members for arranging this. You guys did a fabulous job. Actually, I did not do anything to arrange this one. Frankly speaking, it was all done by the team. Padmaja, Sandeep, Shrikant, Hari, everybody, Shika, everyone. You guys did a wonderful job.
Gopal.
Gopal, of course, Gopal. Yes, yes, yes.
Actually, we're going to call everyone here so we can have a group picture.
Please.
Thank you.
Oh.
Logo.
And little bit of because I've been talking some.
Actually,
Brother.
Ready. We will need some video bites and your testimony, video testimony. So during the high tea and after that, please spare a few minutes for providing your feedback. Yeah. Somireddy Law team members, please come forward. Somireddy Law staff.
economist, a statesman, and architect of economic reforms in the country. India bid farewell to one of its most respected leaders on December 26, Dr. Manmohan Singh. Born on September 26, 1932, in Garh, Punjab, Pakistan, Singh's journey from a young economist to the highest office in India was nothing short of extraordinary. A brilliant scholar, Dr. Singh earned his master's degree in economics from Punjab University, Chandigarh, and went on to complete his doctorate from the prestigious University of Oxford. His career in public service began in 1971 during the Indira Gandhi government as an economic advisor to the Ministry of Foreign Trade. Over the next few decades, he held several critical positions, including Chief Economic Advisor, Director of the Reserve Bank of India, and Secretary of Economic Affairs. He played pivotal roles in India's economic policy at a time when the country faced immense challenges. After Indira Gandhi's assassination, when Rajiv Gandhi became the Prime Minister, he appointed Singh as the Deputy Chairman, Planning Commission, where he served from January 1985 to July 1987. But it was as Finance Minister in 1991, during India's most significant economic crisis, that Dr. Singh became a household name. Appointed by Prime Minister P.V. Narasimha Rao, he initiated bold reforms that transformed India's economic landscape, ushering in liberalization, devaluation of the rupee, and foreign investment. His visionary policies reshaped the Indian economy and positioned the country on the global stage.
When I took over, there were no more than $1 billion. That is roughly equal to 2 units.
Dr. Manmohan Singh served as the 14th Prime Minister of India and was sworn in as the Prime Minister on May 22, 2004. He remained in office for 2 consecutive terms till May 26, 2014. A Congress leader from the Sikh community, Singh also became the first Prime Minister of the country from a minority community. Heading the Congress-led United Progressive Alliance government for a total of 3,656 days, Singh thus became the third longest-serving Prime Minister till date after Jawaharlal Nehru and Indira Gandhi.
So let's give a great applause. It is very sad to lose such a great economic reformist for India. Now we'll pay tribute to Mr. Ratan Tata and we'll have an AV, and then we'll have a 2-minute standing ovation for them for what they have taught us, and we'll discuss a little more about them after this AV. AV, please.
The year was 1962 when a young man of 25 entered the offices of the National Radio and Electronics Company Limited at Andheri in Mumbai. 9 years later, he was the director in charge of the company, and a decade later, the chairman of Tata Industries. In 1991, he succeeded J.R.D. Tata as the chairman of the Tata Group. The youth was Ratan Tata, fresh out of Cornell University, armed with a bachelor's degree in architecture, more than ready to enter and learn as he would rise from the lowest rungs in one of India's most hallowed industrial houses. Today, Tata's contribution to India's largest conglomerate and to the nation's economy was second to none. He was on a pedestal very few industrialists in the country were able to climb. Though he had the magic surname, young Ratan had a tough act to follow, that of his predecessors, Jamsetji Tata, Dorab Tata, and finally the iconic J.R.D. Ratan Tata took on the challenge, and by the time he retired in December 2012, the Tata Group's financials spoke loud about the impact he had. During his tenure, the group's revenues grew manifold, totaling over $100 billion in 2011-2012. Ratan Tata identified the opportunity which the liberalization of the Indian economy provided and began restructuring the Tata Group in 1991. Under his leadership, the group acquired high-profile international brands like Tetley Tea, Daewoo, Chorus Steel, and Jaguar Land Rover. He was also the man behind Tata Nano, the company's small car project, which he hoped would give wheels to the middle class. The journey, however, was not easy and tested his mettle at every turn. First, he had to deal with the satraps, a legacy left by his uncle J.R.D. Tata. Rusi Modi lauded over Tata Steel. Darbari Seth was the final voice at Tata Tea and Tata Chemicals. Ajit Kherkar was the force behind Indian Hotels. And Nani Palkhiwala was the man behind ACC. Each considered these companies their fiefdoms and looked at Ratan Tata as another outsider they had to deal with. 6 years after taking over as the Tata Group chairman, all four of them had resigned. Ratan also wielded the broom on several companies. He exited cement, textiles and cosmetics, and focused his energies on software, telecom, finance, and retail. Finally, after serving as group chairman for 21 years, Ratan Tata retired in December 2012. He had spent 50 illustrious years with the Tata Group. An avid aviator, Tata was awarded the Padma Vibhushan, the country's second highest civilian honor, by the Government of India in 2008. The humble, reclusive industrialist was also known for his philanthropic work. Till his death, he served as the chairman of the Tata Trusts, which are amongst India's oldest non-sectarian philanthropic organizations that work in several areas of community development. The proudest moment for him, perhaps, in recent years was bringing Air India back home to the Tata fold, and while he aimed to touch the skies, his other love was dogs. Doors of even the Bombay house were open to strays all day long.
Wow, 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 wow. What a great inspirational story. What a leader he was. What an inspirational leader he was. A great applause to him. Let's take a moment to show our gratitude and have a 2-minute silence observed for the beloved Manmohan Singh and Ratan Tata. Thank you, everyone. I remember saying of Ratan Tata, which relates to all of us. He said at a time, if you want to walk fast, walk alone. And if you want to walk far, walk together. So let's walk together and we'll go for a distance and hope to see you all soon. Let's have a photo session after the tea break. And also we request you to have some testimonials given to us. And how did you feel about this event? And also I request everyone to follow us on the Instagram page, which will be displayed on the screen later. So I want everyone to follow us and tag this event. And if you have any questions in future or you need any legal assistance, you can always reach out to us. I hope we have given you all the contact information of us, and I especially thank Mr. Santosh Reddy for taking his time and making this even more memorable to us. Thank you, sir. Thank you so much. See you all in next 10 minutes. Let's have a chit chat together with Santosh. So he'll be here meeting you all. So he is available. Thank you all. Let's have some tea. And also, I think Padmaja was thinking that no girl has received a prize, right? Right? Absolutely. So no, we'll not miss that. Okay, once we are back, we'll do a raffle again. Okay? All right. Thank you all. Ladies, please do not move away. Thank you all.